Vinod Kothari sir, Sikha Bansal madam, and all the participants. Thank you for joining this session. The topic or the subjects, I should say, that we shall take up for discussion today pertain to the suggestions that have been made under Ministry of Corporate Affairs Circular dated 18th of January 2023. The same have been put out for public comments, and once implemented, the suggestions would have far-reaching implications, and they shall help us in overcoming many of the challenges that the stakeholders are facing today vis-a-vis the insolvency resolution process under the IBC. Now, to throw light and to enlighten us on those suggestions, we have with us Vinod Kothari sir and Sikha Bansal madam. And let me take a brief moment to introduce our moderators for today. I shall start with Vinod Kothari sir, who actually does not need any kind of introduction. Sir is a fellow member of Institute of Company Secretaries of India, as also an associate member of the Institute of Chartered Accountants of India. And with an experience of over 30 years in corporate law advisory, sir was one of the first insolvency professions in India. Sir has also contributed several books, including one of the very first books on IBC that was titled as Law Relating to Insolvency and Bankruptcy Code 2016. Sir has been appointed as the insolvency professional in several matters, and sir has also been consulted for matters relating to IBC, an accredited and regular lecturer at the ICSI, ICAI, and the ICMA and other professional forums. Sir has conducted seminars in over 25 jurisdictions all over the world. Getting to Sikha Bansal madam, sir, ma'am is an associate member of the Institute of Company Secretaries of India. She also secured All India rank in examinations conducted by the institute. Her core area of expertise include insolvency law, law relating to security interest, corporate laws and financial regulations. Ma'am is also a co-author of the book Law Relating to Insolvency and Bankruptcy Code 2016 and has authored several articles on subjects pertaining to insolvency law. She has been engaged extensively in resolution and liquidation matters, as also advisory under the IBC. So with that brief introduction, may I request Vinod Kothari sir to take over. Sir, over to you.
Thank you, Nitinji, and very good afternoon, everyone. As usual, it's always a great pleasure to be interacting with professionals around the Insolvency Bankruptcy Code. We are today discussing the MCA notice proposing more than 30 changes in the Insolvency and Bankruptcy Code. And I would start by first saying that there was overwhelming feeling coming from all circles. In fact, today's Economic Times carries an editorial piece on this very issue, that the Insolvency Bankruptcy Code was launched with a great fervor, with great hope. The entire world was looking at it extremely optimistically, as if this would resolve the long-standing problem of sticky and slow movement of resolution matters in the country. We had experience with DRTs and SARFAESI earlier, and we were hoping that this law would make a huge difference. Now, no one is saying that the law has not made a difference. The law had made a tremendous difference. I think we all agree that the law has made a substantial difference, particularly when it comes to the culture of meeting contractual obligations in the country. I mean, the message that it's thrown to all the businesses and all the industrialists is that if you don't meet your contractual obligations, you can understand what the fate of the entity would be. So that way, it's done a great job of leading to a cultural change. However, if I would say the highlight of the code was timely completion of processes, because everywhere it talked about time. Not that insolvency was anyway new in the country. Insolvency was there in Companies Act. It's always been there over the years. But what was missing was timeliness. And therefore, the strong point of the law with which it sort of sought to distinguish itself, everywhere it talked about time-bound process. CRP time-bound, admission of CRP time-bound. There are strict timelines for the resolution professional. There are strict timelines for almost everything. There's a timeline for liquidation as well. The timelines everywhere. It's a completely time-bound process. In reality, how much have we been able to live to those timelines is not something that I need to tell you all, because you all are from practice and you all understand very well that most of the timelines are actually there in theory. In practice, the timelines have no meaning at all. Even the IBBA itself has recognized that while the adjudicating bodies have 14 days to admit or reject insolvency application, I mean filing of CRP applications, the time taken in reality can be more than a year. Many matters which were filed, I mean, they're probably there before benches for more than a year. They have not even come for substantive hearing. So the question of either admitting or rejecting an application in 14 days remains as a pious objective. So the whole idea was, can there be some reform in the code whereby the languishing procedures can be simplified, shortened? Can there be some fundamental changes so that the places where we're killing time right now can be saved and eliminated? The whole idea basically was, can we streamline processes? Can we streamline the law? Can we learn from experience of past 6 years and therefore move forward? Now, there are few positives that we see in the approach of the government. Unlike the past regime where it took years and years for matters to be resolved, when it comes to IBC, we find resolution, that is resolution of difficulties, happens fast enough. The government has been extremely responsive. Amendments have been done to the code as and when needed. And now after 6 years of history of implementation, if we had some strong observations about certain things, the government is fast in introducing changes. That indicates the sensitivity, responsiveness of the regulator. And therefore, we are able to see a very responsive regulator. That's one noticeable feature. And the other noticeable feature is that of all the changes which have been done in the past, this is obviously the most comprehensive, the most significant one. No, Sikha, you can maybe leave the slide as of now there.
Sure, sir.
So this is one of the most significant, one of the most comprehensive amendments in the law. And it goes to make some extremely fundamental reforms. So I would say this is for the first time that we got a very bold, very far-reaching, very, very comprehensive intent of reforming the law. And that's what makes it extremely significant. So today, what we're going to do, and my job and the job of my colleague Sikha would be to act as moderators. We are not the ones who are supposed to supply inputs. The idea basically is to collect inputs from all of you. All of your practitioners, all of your seasoned professionals, all of you have been through experience of implementing the law. And the idea, therefore, is to gather feedback of professionals on these 30 plus proposals to amend a 6-year-old law. So before I proceed, maybe I'll just do a quick listing of what changes have taken place. We got a long list of 30 plus changes. I don't intend to read the entire list, but I'll just maybe make a quick zooming past those amendments and pause to make a point where we think the amendment is extremely significant. For example, the first change proposes, and I must once again submit that all of us here, 65 participants already joined in. All of us have free right to interact. That's the whole idea, to collect your feedback, to be able to give a meaningful feedback on behalf of ICSI IPA to the MCA and to the IBBA as to this is the learning from this roundtable. It's a roundtable. It's not a speech session. I'm just a moderator. So is my colleague Sikha. So in terms of the amendments, number one, use of technology, that would be to the extent possible, automate processes. And there'll be some further comments we need to make on that. And number two, information utilities to be relied as the source of information about happening of a default. That also goes to somehow give overarching credibility, that information utility, if it's shown something as a default, then the question of whether the default has occurred or not, that question already stands answered. And we'll like to talk about that. Mandatory to admit application under section 7 if evidence of default is available. This is basically to overcome the ruling of Supreme Court. I don't need to say, you are all aware which ruling I'm talking about. Restricting the right of promoters to propose interim resolution professional in case the application is being filed under section 10, which is the corporate debtor itself. The proposal, the name of the IRP will not be suggested by the promoters. It will be selected by the adjudicating body itself. That's the proposal. There's a very, I would say once again, a very timely proposal for decriminalizing. That would mean moving from fines to penalties in the same manner as has been done under Companies Act, LLP, and a whole lot of other economic laws. So Section 235A, providing for omnibus fines, that would mean a fine for breaching any other provision of law for which there is no specific penal provision. That is supposed to be decriminalized, meaning moved from fines to penalties, and the right to impose penalty will be given to the adjudicating body itself. Fast track insolvency process will be largely non-adjudicative, such that we go to the adjudicating body only when the ultimate dissolution order or ultimate decision on the resolution plan is to be done. The scope for pre-pack is supposed to be expanded to move it beyond SMEs and to move it to larger entities. Which larger entities? That list is to be specified by the government over a period of time. Improving the outcome in real estate cases. Essentially, this is widely talked about in public domain, because in whole lot of builder insolvency cases, the home buyers have been put to substantial difficulty. So that's a public interest matter. And what the government proposes to do is, if there are multiple projects being developed by a developer, then the resolution of insolvency can be taken project-wise rather than entity-wise. And there, while the entity is in resolution, that will not stop the developer from doing conveyances of the flats. But that's I would say that's what you call, that's a sort of a ongoing business, and therefore the ongoing business, which is completion of construction and the conveyances of apartment, that should not be stopped. Then comes the next proposal, which is multiple of partial resolution plan. This is very interesting, though in some sense it's already been done by way of the amendment of regulations, but now we need to statutorily incorporate partial resolution. That would mean if there are multiple businesses, then instead of waiting for a lock, stock, barrel resolution of the entire entity, we look at the undertaking-wise resolution, enterprise-wide resolution instead of entity-wide resolution. Assuming the entity has multiple enterprises, we can think of resolution of an enterprise without bothering about resolution of the entire entity. Another very interesting proposal, this is quite interesting, is to segregate resolution and distribution of resolution proceeds. Because currently what happens, the resolution applicant not only indicates how much is he willing to pay, he also indicates the manner of distribution. He says how much I'll pay to FCs, how much will I pay to OCs, how much will I pay to the workers, and so on. So now that part is taken off from the resolution applicant. Resolution applicant will say how much is he willing to pay, and the distribution from there on would be the domain of the committee of creditors, of course, with approval of AA. Swiss challenge method is being used in several insolvencies right now, so we need to see how it's getting codified in the statute now. COC will be empowered to also monitor. This is also already there in the law, but probably further details are coming on that. Then comes reinstating CRP even after commencement of liquidation. In certain cases, if liquidation commenced, and liquidation is mostly irreversible, that would mean once liquidation has started, we cannot revert back to insolvency any further. All we can do is to do a going concern sale and liquidation, but now the statute will be amended or proposed to be amended to revert to insolvency even after commencement of liquidation in certain given situations. We'll need to talk about that later. Then intermingling of assets of the corporate debtor and the assets of the guarantors. If guarantors own certain assets, and the assets are the assets over which the working or the functioning of the corporate debtor is dependent. For example, the land over which the plant stands, or the trademarks which are owned by a group entity. In that case, the assets of the guarantor may also be amalgamated with the assets of the corporate debtor, provided the guarantor's insolvency also has been invoked. That's a point which will require some discussion. Going further on the process of group insolvency, further extension of the idea of insolvency of a group. And a group, once again, has been defined. Here we're talking about a coordination approach, not consolidation approach, to resolving group insolvency. Very, very important change. Operational creditors proposed to be put at par with financial creditors. When it comes to waterfall, Section 53 currently has distinct. Item number D is unsecured financial creditors. Item number F is unsecured operational creditors. Now, those hierarchies are supposed to be collapsed into only 4 classes. Category 1, of course, as usually expenses. Category B is workmen and the secured creditors. Category C will be the employees. Category D will be all other creditors. That would mean without making a distinction between unsecured FCs and unsecured operational creditors. And a very, very significant proposal to change the waterfall. Changing the waterfall. The waterfall clause is the very crux, the very essence of insolvency law. And amending the waterfall by collapsing categories is like a very, very fundamental reform. So that's an important point on which we need to talk about. Then this is once again overriding implication of Supreme Court ruling in the case of Rainbow Papers. Statutory secured creditors will not be taken as at par with secured creditors. Valuation estimates to be disclosed in information. I think this was there in the regulations earlier. It's supposed to be now codified into the law. Number 16 is also arising from a Supreme Court ruling in the case of Gujarat Urja Vikas Nigam, where the Supreme Court said the statute needs to have provisions for continuation of contracts. If the entity in question is gone into insolvency, the fact of insolvency may itself lead to termination of contract, termination of contractual rights. So to preserve the contractual rights, the court recommended the law to be amended. This was done quite some time back, but nevertheless now the court seems to be incorporating this principle, though with certain reservations. Number 17, civil protection to be applicable to resolution applicant. To my mind, this is simply extending the current provisions of Section 32A. Number 18 is very, very important. I'm sure all of you are in practice would say that today a creditor who is part of COC may sort of defunct the entire proceeding in the voting process by not coming for voting. Because we are counting voting strength not by looking at how many people voted, but by looking at the total voting right. So this is a very, Sikha will probably discuss it later, but we will see that this is the view that we've been saying since 2016, that that's what, even without amending the law, that is what the correct reading of the law should have been. But now we are actually codifying this in the law, that while counting voting percentage in COC, we will not talk about total voting strength. We will talk about the percentage of those who have voted. Now, even while we are introducing this in the law, we are bringing a further caveat, a further restraint, which to my understanding is not the right restraint to keep. So as we come to discuss this, we'll talk about what restraint are we bringing and why is it not good. So this is one point that if you all agree, then we might probably give as a part of our feedback. Let's come to this as we discuss it further. Next, interim financiers are to be given right to be on the COC. There's hardly an interim finance to my understanding in the country. Interim finance, or so-called DIP financing, is a very strong practice in other countries. In India, it's not picked up at all to my understanding. However, you can give your feedback as to what is it that is missing in the law. Why is, because of which interim finance during liquidation is not working in the country. The government wants to get a right to appoint administrator. That would mean instead of an insolvency professional, a government appointed administrator, like what is currently happening in case of NBFCs, or I think banks have not gone into that stage still, but well, banks have gone into Banking Regulation Act. For example, RBI does appoint administrator in case of banks. So the government wants to keep a power in case of public interest involving a public interest matters, to have the right to appoint administrator who would work as the resolution professional. This is something which is quite new and we need to discuss that. The government also want to keep a power to exempt a class of companies from the provisions of the code. Then certain amendments in individual insolvency, that is primarily for the corporate, for the personal guarantors to debts of companies. A provision to permit the NCLT or the AA to order dissolution without without undergoing the process of liquidation. That would mean jump the process and go for dissolution straight away if there's nothing in the company to actually sell. Next point comes elimination of duplication. That would mean certain things that we do during insolvency will not need to do once again when liquidation commences. Creditors to this is another very important part. Currently have a stakeholder consultation committee, but now the court proposes that there will be a COC during liquidation as well. We'd like to get the feedback of participants as to how do they see this process. Do you think that during liquidation as well, commercial decisions of the liquidator are dictated by creditors? Is it, and that too of multiple rankings, does that actually practically work? Is a question that we need to assess your feedback on. Replacement of creditors, well, with creditors or what you call super majority vote. I think that's there in the law already, but that's what is now sought to be codified. Stay on continuation of other proceed. This is another very important change because in the Companies Act 56, Companies Act 2013, winding up processes, there always existed a provision that if that companies and winding up, then litigation against the company in various forums, for example, labor court, this court or that court, civil court here and there, will all get concentrated in the winding up court only. Because the liquidator cannot be running from a court to court, he will probably be handling liquidation in one single court. And that was, I would say, time-tested principle because as the company is passing through a terminal path of liquidating its affairs, if litigation continues in different forums, that doesn't help the process at all. So now this provision is sought to be brought in the law that other proceedings in different forums will get stopped once liquidation commences. Realization of security interests under Section 52 will be permitted only with the unanimous consent of all the pari passu charge holders. That's part 1. And part 2, like currently, there's already a provision in regulations for having a maximum time within which the creditors have to decide whether they would like to relinquish security interest or not. So if they don't come back within 90 days, then they would have been deemed to have relinquished the right. Finally, there are some provisions about insolvency or whatever, insolvency service providers as well. So that's a broad almanac or broad view of the changes which have been proposed. If you can just scroll up a bit, Shikha, and just stay there for a minute. So if you were to broadly classify the changes can be classed as number 1, some bit learning from past experience. For example, voting of COCs, enhancing the scope of pre-pack. We know that pre-pack virtually failed because there have only been 2 pre-packs so far. So some are learning out of past experience. There are some which are which are already there in the regulations. We're simply putting them in the statute now. There are several changes which are trying to overcome the impact of Supreme Court rulings, but there are several changes which are indicating basic fundamental progressive thinking. For example, partial resolution, collapsing of the levels or hierarchy in the waterfall, separation of resolution and distribution, resurrection even after liquidation is begun, aggregation of assets or group insolvency, etc. These are all progressive fundamental changes. Let me move to my colleague Shikha, who would maybe move from here on. Shikha.
Sure, sir. So so at the outset, we would like to state that the approach would be consultative here, as Vinod sir clarified that we are acting as moderators, and we would of course like to have the view of the audience here. So I would just touch upon the proposals broadly and would keep the questions open for the participants to provide their inputs. So the first proposal relates to automation and the use of information technology. Basically, the idea is to integrate the interaction between different stakeholders, including MCA, adjudicating authority, IBBI, IU, insolvency professionals, and other service providers as well. So this proposed e-platform is expected to provide various services. For example, case management system. So the idea is, like, at present, the platform is kind of scattered. The idea is to streamline and collaborate. And the services which can be expected is case management system, including storage of records of CDs undergoing the processes, and where, the platform which can enable interaction of IPs with stakeholders. While we understand this is a progressive step, however, we can also discuss as in what can be the other possible expectations from information technology insofar as its usage in IBC processes is concerned. Any inputs are welcome.
Thank you, Sikha. Thank you for a good briefing. I am Ravindra Baliyur.
Hi,
See,
sir.
I would expect, I'm not sure whether they are planning this. There are many times we would be doing the reporting the same aspect again and again. It could be something to do with what cases we are handling at the end of the month. It may be to do with reporting connected with the legal cases which we are reporting. So there should be one, I'm not sure whether that is intended in this particular proposal. I think there should be a very comprehensive reporting system to IPAs and IBBI, so that there is no duplication as such. And I think this is, I'm not sure whether it is included in their proposal. I think this is something which the system, there should be such a system so that there is no duplication in terms of reporting and compliances by IPs. This is one point I think it is relevant for this aspect.
Okay.
Thank you.
My name is Shivaraman. Hello.
Hi, sir. Yes, you're audible, sir.
Yeah. See, there should be only one end of reporting. For example, if I send it to IPA, that information should be transferred to IBBI. Sometimes I receive information that IPA also asks the same information and IBBI also asks the same information, which is not warranted. This is something happening sometimes. See, for example, it is one end. I report to someone and from there it takes on. Second thing is, for example, a very peculiar case which happens. IBBI knows what the case number is and what the NCLT hearings happen. But they ask for information, what was the last date of hearing? When such an information is available on the website of the NCLT. Asking the RP to spend his time to tell what is the status, how many hearings have happened. Is it a right question? When it is available in the NCLT website about the case number, what are all the cases running, everything is known in the NCLT website. And unwanted, sometimes what happens is you are putting too much of pressure on the RP to do certain aspects of the job when he's supposed to be on the field looking at some activity. This should be curtailed and it should be brought in such a manner that there is support. Once I report, it is reported.
A single integrated reporting system, basically, you're talking about. Got it. Got it. Vinod sir, your views?
No, I think Mr. Devang Sampath also has raised his hand, wants to say something. And Sikha, I'm hoping that some of us are keeping notes of the very important feedback.
Yeah, so Neha is keeping a note of that.
And Mr. Devang Sampath would like to maybe add.
My input on this is,
sorry, sir, your voice is not audible, sir, properly. Still not.
Okay, I think while he works with his audio, Sikha, because part of the screen is getting connected.
Hello?
Yes, sir, you're audible now.
Okay. Madam, my inputs on this are, first, the integrated system should be integrated in such a manner which is not one-way reporting, but two-way reporting, where even the financial institutions, government departments, etc., entire data as you are trying in IBC 21, should be available to the IRP on day 1 or day 2. The bank statements, the forensic audit reports, the stock statements, the income tax returns, the sales tax returns, the custom returns, etc. Second, integrated for regulators as well as adjudicating authority. To the extent that maybe if, with due respect, as per NCLT rules, we are as IPs are required and notice are required to file IAs, etc. for reporting every progress and other reports. Maybe if some changes in Evidence Act or something could be thought of, NCLT rules, where the reports, etc. could be through a single system. Third, even the notices, minutes, etc. of stakeholders meetings, COC meetings, etc. can be through the same system where they are given. The email IDs would be input by IPs and automatic. Of course, he will or she will try and deliver himself and herself also. But even through system, they can be done. Third thing is, maybe another point on this is, even maybe the prospective resolution applicants, etc. Whatever is the data which is givable to them can be through the same system. Even whatever the data the creditors and others can be having approach to, they can be given login and limited approach to whatever the law enables, and they can definitely go through that, so that a lot of litigation which is around the data, etc., would be reduced to a very great extent. This is my submission on this particular point.
But sir, there is already a data room concept in case of resolutions, right? That's anything different which you are wanting to propose here, there?
The PDA, etc., which is there for resolution is specifically for resolutions. I'm talking of a single integrated system where the data is provided two ways and is available everyone through the system through login IDs and automated email IDs. Even when the claims have to be invited through from books of accounts and liquidation, etc. Maybe the promoters can provide the email IDs, the IP can input the emails, and even the invitations, Form G, Form B, etc. can go directly from the system to everyone. So a single integrated system, be it for resolution, for reporting to NCLT, for reporting to adjudicating authority, or communication with all the stakeholders, everything in a single system which is open to, fully open to adjudicating authority, regulators, IP, and to the extent others are allowed in that system. That will make life of everyone simple and a lot of litigation reduced. Of course, it's a very tall task being asked.
Correct.
But definitely we can start with small steps in that direction.
Sure, sir.
Maheshji?
Yeah, good evening. I have only two suggestions. Like this publication of initiation of CRP. We have seen that in most of the cases, people come later on that we were not knowing that CRP has been initiated because the law requires that it is to be published in a vernacular and English newspaper in the registered office of the company. Or other is option. You can give to other places. It is up to you. So how it can be widely circulated, there should be something. Secondly, like our friends have said, like reporting to IBPI and IPA, there is a duplications. Plus, many a times the information required by them is not very clear. They should have a very clear, requirements. And in many cases, IBPI after sometimes ask for resolution format, liquidation format, like that. So let them be in a initial stage or at the end of the CRP only. Whatever information is required, let it be at that time only.
So Sikha, I would say I think no one is opposing this idea. I'm sure no one can oppose this idea.
Yes, sir.
People have given various expansive ramifications of this. The idea proposed basically is an integrated case management system. But I think we have even more ambitiously gone into something which is encompassing a whole lot of other things as well. I think that's okay. Good suggestion. We'll keep note of it and maybe forward it to ICSI IPA for moving it forward. But as far as this proposal itself is concerned, there is no question of anyone not not favoring this. I think everyone is appreciating this proposal.
Sure.
It's
small concern.
It's almost like a no-brainer. Maheshji, what?
Sir, I have a small concern.
Yes, Venugopalji.
This is I'm calling from Hyderabad. The point is, most of the cases in liquidation, much money is not left with corporate data to carry out the process. Data room is very costly. Virtual data room is very costly affair, and many cases will not be able to afford also. In that case, see, Google Drive, can we make use of the some other alternatives like Google Drive or any other option? Because company cannot afford it. Corporate data cannot afford it. We have to pay from our pocket.
Venugopalji, the concern is quite well appreciated, but I assume that when IBBI or MCA is talking about a case management system, I believe this will be available for use as a licensed user to insolvency professionals. That's the whole idea. For example, the NCLTs will be using it, IBBA will be using it, IPAs will be using it. Likewise, I think the IPs will be using it. It's not, I don't think they are meaning to say that even the data room will be a part of this, but not sure to what extent will it be, what will be the scope of this integrated case management system, but perhaps the right of usage will be probably there with IPs. I think that should probably be a part of the package. I'm not sure on that, but well, the concern that Venugopalji has mentioned is one of the concerns which also may be taken note of. Ashika, given the fact that we have a whole lot of other extremely important.
I'm moving forward.
Right. So I think everyone is appreciating this particular one.
Vinodji, I just want a request. That request is that the members should restrict to whatever the proposal rather than bringing something unrelated with the specific point we are discussing. Then we may lose the focus. That is my humble submission.
Right.
Sure. So the next
proposal, this one you can explain the proposal, Sikha, and then maybe take feedback.
So the next proposal pertains to making IUs as a sole and conclusive basis of default confirmation. We all understand there are other sources of confirmation of debt. For example, there is ROC registration, there is SAFEZI. In case of default, one has to prove the existence of default. Now, while it is mandatory for financial creditors under section 2 and 5 to file the financial information, it's not mandatory for operational creditors. However, there were recent amendments in CIP regulations, where under regulation 21A, it was said that even the OCs will have to file for default if they want to apply under section 9. So now this proposed amendment basically wants to transpose this regulatory amendment into the code itself and wants to stipulate the same mandate on OCs as well. So again, here what's our view is that there is no, so you would want to explain?
Yeah, the concern that we thought would still be there is that in case of operational creditors, we're talking about a commercial claim.
Correct.
In case of financial creditors, it's a simple case of a financial facility. The grant of the financial facility is a part of the information utilities records. It's there in several other records, for example, CIBIL or CRILC for that matter. And the existence of default is also something which can be cross-verified from CIBIL or CRILC records, as also from records of information utilities. So probably the IU was seen as a comprehensive database of financial transactions involving, provision of credit facilities. When it comes to operational creditors, he's not in business of registering his transactions, which are purely commercial, with the information utility. For example, some supplier of goods or services. What does he have to do with information utility? So merely because he intends to file an application on occurrence of a default, he goes and registers the default with information utility. Now the proposed amendment says that if at all such a default is proposed to be noted by an operational creditor, the IU, information utility, in turn will have to give an opportunity to the company, to the corporate debtor in question. Therefore, the corporate debtor, I'm sure, if it's a commercial transaction where there are commercial disputes, I'm sure the corporate debtor would have something to say. So are we wanting the information utility to be a sort of an adjudicating body to keep record of contested claims of people? Somebody says there's money due to me. Somebody says no, money is not due to you at all. So when it comes to contractual claims, which is what the very sense of information utility is, which is the very sense of operational creditors is IU the right place based on which a decision to admit insolvency would be taken? Because if we can actually contest the claim before the NCLTs, and I'm sure the CDs will contest it before the IUs also. The IU is not a forum to decide on such matters. The forum is really adjudication. So moving adjudication to IUs probably will not serve any purpose because it's merely noting of a default which anyway will be contested. So we thought maybe it could probably stay limited to financial creditors as is the case currently, but nevertheless, that's the proposal. So I'm able to see that Mr. MG and Devangji both have raised hands. So Mr. MG.
Yeah, this is related to financial creditors alone. In even financial creditors, some portions like real estate allottees, home buyers, in other words, are not being covered under IU. A lot of claims related, probably delays, issues, and more of IAs in court also for delayed claim filing. Everything is related to home buyers only. If at all you closely watch the real estate cases, CARP cases. My suggestion, instead of probably operational creditor, they would have actually considered or should have considered or consider the real estate claims through IU.
So that's a fair, valid point because the failure to, I mean, in case of a home buyer, the failure to deliver the property based on contractual agreement is treated as a financial debt by virtue of amendments made in the law specifically for home buyers. And if it's taken as financial debt, then nothing, the evidence of that failure may also be moved to information utility, and probably the IU could be more useful there.
And especially if at all you closely watch the real estate cases, and majority of the activity of the RP is that admitting the claim because delayed claims and related to thereof the cases in NCLT for admission and other things, right? So that can be avoided also. This will ease up the thing.
I agree with you, sir.
Thank you.
Mr. Devang Sampat?
Sir, mine is suggestion. I welcome the suggestion. However, there should be a sunset clause for existing this thing, existing operation creditor and other things besides financial institutions. And future, whenever a goods or a service is provided, they should register in IU. So present registration at the time of sales or providing of services or allotting, etc., should be prospective. It maybe IU should not be made as a adjudicating authority or a court for claims which have already been defaulted, etc. So with a sunset clause and prospective of registration in future at the time of providing may sort out this issue which we are presently facing. And getting a default from IU is always welcome because this will reduce stress on the system. And another point is, today the threshold limit is 1 crore rupees. It is not 1 lakh rupees. So someone who can provide a goods or service of 1 crore rupees or above 1 crore rupees outstanding is definitely an informed person or is a person who can afford services of a professional. And the fees, etc., are only few hundred, 200, 300 rupees at the most for registering in the IU. But this will reduce stress on the system and things may bring many things online on board. So I believe with sunset clause, most of our problems will be solved. That is my suggestion.
So, Mr. Devang Sampat, you are actually meaning to say that if at all it's prospective, I mean, if it's prospectively applicable, which I'm sure it would be, because normally law is always prospective, then this is doable.
Yes, sir. Prospective in the sense, not the defaults. But today, if I'm providing
prospective supply of goods and services, I understood your point.
And maybe existing, if someone is accepting the default, even then it is perfectly fine. That much of stress on the adjudicating authority would reduce. So, but for past, maybe it will keep open through all the systems, traditional system as well as IU system. Future, it should be put to IU system with a sunset clause.
Mm-hmm. All right.
So okay. Moving forward, sir. Yes. So this third paragraph. Of
sir, if I'm allowed to intervene here for a moment, sir.
Sure.
Sir, this is Rajkumar Baito. Sikha ji, yes. Sir, actually, for Section 9 applications, I mean, it's not uniform across the board. Like if you go to Delhi NCLT, then they ask you to just go for information under this IU. But whereas in some other NCLT, they don't press for this. So this thing should be uniform across like in all NCLT so far as procedural part is concerned.
Maybe that's why they are inserting the provision in the law, Rajkumar.
That's why. Okay,
Mhm.
so
May I come in here for a minute if you don't mind?
Yes,
sure.
sir. Yes, sir.
See, the point is that the biggest disadvantage of allowing the operational creditors to use IU. IU is a platform basically with information, not for creating and not as an adjudicating authority. The issue is that if you look at the whole provision, the key to deciding on an operational debt as far as the AA is concerned is a pre-existing dispute as per the Mobilog's judgment. Now, you are giving a platform to create a pre-existing dispute because the moment there is a default that is notified here, it will not be confirmed. A dispute will be created, and that will be contested as a pre-existing dispute prior to the demand notice. So that is where the issues could come up in terms of this going forward. So we need to have some checks and balances on that aspect before the Section 9 cases are permitted to use this platform.
Maybe counterproductive, that's what you're saying.
Yes. Could be. I mean,
It would almost like backfire because if there was a contest at the time of making entry in IU, that will be taken as a case of pre-existing dispute.
Yes.
That's the that's a possibility, surely. So we'll need to be already guarding for such a possibility.
Sure. So shall we move ahead? Okay, so the third proposal basically is a response to the ruling of Supreme Court in Vidarbha Industries, where it was said that NCLT can actually exercise discretion in admitting or rejecting a CIRP application, even if the default is established. So this proposed amendment basically seeks to insert a clarification in Section 7, basically two sorts of clarification where it puts a mandate on admission of application if default is established, plus the timeline of 14 days is not only to assess whether there is a default or not, but also to either admit or reject the application. This, to our understanding, should be a welcome move without any doubt. However, Vinod sir may give his views as well.
Sikha, all I was saying was that, are we therefore saying that now the timeline for the adjudicating body also will be mandatory? All along, we understood that timelines for the adjudicating body are
It's always directory.
And 14 days could be 140 days or maybe 360 days, doesn't matter.
Correct.
So are we therefore saying that if its petition is taken on record, in that case, 14 days time and with an evidence of default?
Right.
So to my mind here, I mean, the earlier proposal about use of automation could actually be very handy here. And I think there was a mention in the earlier slides as well that increasingly all over the world, judiciary started making use of artificial intelligence, which would actually mean the machine which is capable of deciding that there is a default based on the information stored in IU. The machine can decide that there is a default. The machine can therefore come to virtually a decision. Decisions ultimately have to be taken by judiciary. There's no doubt on that. The fact that we engage artificial intelligence does not mean judges are not deciding. Judges are still deciding. But judges are aided and assisted by artificial intelligence. So perhaps here 14 days time would become practical the moment we say that there is use of automation, we're relying on information stored in IU, and therefore other than verifying the fact that there is a default in IU, there's nothing much that the adjudicating body has to do. And therefore let's move on fast here, because I think cases are losing almost like a year in the pre-admission stage itself. So it's time to maybe limit that time and come and do some hard thinking, some bold thinking, and say there is no question of this time being directory. If there are timelines for everyone, is it okay that there is no timeline for judiciary at all? After all, we're part of the same civil system. The courts as much are part of same civil system to which all of us are subjected to. So how is it open for the courts to continue to say that there's no timeline for me? So I think this is, though sounding little, I would say, audacious, but I think it's time to actually take a hard look at that. That was one part. And of course, now it's anyway a foregone conclusion, which is anyway was the design of the court, that we are not looking at reasons for default. We're looking at the fact of default itself. We're not looking at solvency test anymore. We're looking at liquidity tests. If there's a default, then the outcome is very simple. It's a case of insolvency. So that's my take, but I'm hoping if there's someone else who would like to contribute on that.
If no, moving ahead.
Mr. Devarajan Naman sir.
Yeah. See, the issue here is that you're trying to basically get over the Vidarbha judgment, which of course is still under review. Now, the question that we need to understand that natural justice cannot be dispensed with. So obviously, whatever amendments you make, to that extent, I am somewhere Supreme Court will hold it ultra wise, the Constitution. So that danger still exists in this, because if you look at Vidarbha judgment, the basic ratio there was that I have honored my part of the contract, you have not honored your part of the contract. So obviously, how do you have anything against me till you do that? That is a basis. So here the natural justice issue comes in. So we need to see how the courts will deal with it. So it will be interesting. Going forward, we'll get an idea.
Yeah, I think that's right, because the Supreme Court has admitted a review of the Vidarbha ruling, and we'll look forward to, with great respect, learning from the Supreme Court. But in the meantime, at least the policymaker's stand has always been very clear. The policymaker's stand has been that there is no question of examining the reasons for default. The default is the default, no matter why it occurred. There is a question of natural justice, sure, but in that case, the natural justice will all lie in proving that the contention of the applicant that there is a default is not a correct contention. If there is a default, reasons don't matter, the default is default, and therefore that's all that is required. Perhaps that's the thinking of, that was the design of the BLRC, and probably that's what the intent of policymaker seems to be. Mr. Shivaraman?
Instead of 14 days, let them make it 30 days, sir. Let them make it as a month.
But then live with it.
But fix it.
Then limit it. Decide it. See, whenever you go to the judge, he says, I will take my time. You cannot you cannot go against him. You cannot contradict him in the court, or otherwise you will be pulled up and you will be put fine on that.
Our minister, Mr. Viju, is openly doing it every day.
Yes, they do it.
He's defying judiciary left, right, center every day.
So that is what is the thing. First of all, we have to make the judges understand that 30 days time, yes, the time you have to decide a case, yes or no. If you are finding it 14 days is a bit difficult for you. The point is, everybody in the system, the stakeholders, everybody, the judiciary, the government, IBBI, everybody should be on the same plane. One talking something and other not listening, it's not right on the part of the RP. What is it? To pull up the RP in the case.
Yeah,
that's my submission.
Pulling up the RP is the easiest thing for everybody.
Easiest thing everybody has.
And everybody does it. That's something that all of us are party to it. And let's however, this is an extremely
instead of 14
point.
days, my time, I would rather say make it 30 days, make it practical.
Make it practical and then live with it, because then don't say that time.
And one more thing. For example, if you file an application, you should give an opportunity for the other side to represent his case, right? There is always a representation from the other side. You cannot decide from one side. So there should be a definitive timeline. For example, if I file an application and it comes to the thing, the respondent should say, I will file my reply within a week. He should not say, I will take 2 weeks to file my reply or 3 weeks to file my reply. It should not be the case. Everything should be delivered.
That can actually be made a condition precedent, because what we mostly see that when you file it, though you served a copy on the other side already, the moment the first day comes, the court says, have you served it? Then say, I'll direct the registry to serve a copy. The court insists that the registry of the NCLT should serve a copy, though I have produced an evidence of serving a copy on the respondent already. So that can be actually made a condition precedent. If there's an application, before it is filed and taken on board by the NCLT, evidence of serving it on the opposite party is already recorded. And once that evidence is there, it should be good to proceed with, without asking for the registry to serve further copy and therefore unnecessarily kill time. But the point that Mr. Shivaraman has made is extremely valid, that if we talk about an ecosystem, and we're talking about insolvency as an ecosystem consisting of several players, IP is one significant player, ICS, IPAs and IBB are, let's say, supervisory and regulatory bodies. The NCLTs are also a very important part of the ecosystem. To say that one part of the ecosystem is free from timelines and therefore no timeline works for that system, I think is ensuring the failure of the system. How can any system work where one element is bound by timelines, another element says that no timeline works for me? So that is, I mean, and I'm sure all of you would agree that the biggest bottleneck today in the 6 years of implementation of IBC, like in the earlier regime, we would say the delays took mainly in the courts. And I think here again, we're repeating the same thing. The delays are mostly happening in the courtrooms. So we need to understand that that's exactly where we need to work on. We need to do some bold reform there. Some bold reformer has to come and say that there is an answerability on the part of the NCLTs as well for every day that they lose in the matter. Maheshji?
Maheshji, yes. Oh, Maheshji, will you want to speak something?
Yeah, sorry. I just want to add here, see, normally what we find that delay by NCLT is mainly due to lack of members in the benches, lesser number of benches, and unnecessary admission of various applications. So I think we need to address these issues also.
Maheshji, if let's say my office takes a view that my office did not have adequate manpower, therefore I delayed in filing, will it work? If it doesn't work for me, how does it work for NCLTs? To say that I don't have members, to say that I don't have enough number of benches, every part of the ecosystem has to honor its own responsibility without finding internal reasons for not doing it. That reason is internal to me. I think you're right, that system, that infrastructural issues have to be resolved. But that's where it goes back to the appointing body. But in any case, the point is that every part of the ecosystem has to be equally responsible for meeting its own timelines without any internal reasons. The point that you made, Maheshji, is well noted, though, that we know that there are infrastructural issues. Mr. Devarajan Raman also wants to say something.
Yeah, I just
wanted to say, I mean to that only. I'm not saying the AA should not stick to timeline, but through IBBI or appointing body to AA has to be awakened. You put the people or system in place fast. Like if you have lack of staff in your office, you will take a decision to appoint persons.
Absolutely.
Similarly, the appointing body has to act and take this issue.
Point made. Mr. Devarajan, sir?
See, the issue is something like this. We have to look at ways how to reduce the delays in NCLT. That is the point. Apart from members is one issue. The other issue is that if you look at the matter coming up, these days you file an IA or a petition, it comes up, of course, in 3-4 days. That's a good thing. But the point is that the time given for reply is too long, right? Almost you get a date almost a month back later, 30 days or 45, 30 days at least. Now, why can't we have a system where you have a standard format of application that is section 7 or section 9 or whatever, section 10? Why can't we have a similar lines, a reply format just addressing those issues made in the application, which is made standard and that has been filed in 3 days to 6 days? That could possibly shorten the timeline. The rest can be taken up at the argument stage and the written submission. So this could also possibly, save time, provided, of course, this structure is accepted by NCL. That's the point. This is one loud thought I am making.
No, I think the point is very valid, Mr. Devarajan, sir. I also have a loud thought on that. I would say instantaneous loud thinking, but at some stage, the NCLT system has to start or has to disable a counsel to speak beyond, for example, if it needs 15 minutes, 30 minutes, 45 minutes, disable it after that. So that it doesn't continue speaking for 2 hours.
In fact, for a number of days.
So I think ideally the time to a counsel, like time for everything is limited. Well, if you got half an hour to make your case, make it in half an hour. I think that happens world over.
Yeah,
Counsels
yeah,
are
of
not,
course.
not
Here
given
some
indefinite
courts do
time.
it. Here some courts do it, but normally not to the senior counsel. You know, the junior guy
So
is
that's
not here.
senior or junior. Law cannot look at the face of the advocate. Law has to look at the matter. I mean, that's one of the most important principle of judiciary is that don't look at the face of the person who is arguing. And therefore apply it uniformly, limit the time. Ultimately, it's a question of time which is precious for everyone. I know that quite often I can drag the same matter for 2 hours saying, let's say, what could be said in 2 minutes. If that's what, I mean, senior counsels or whichever counsel does it, we somewhere have to curtail that time. Mr. Ravindra Belur would want to say something, sir. And
Yeah,
Mr.
I mean,
Ravindra.
just a point. This has the connection with what Devarajan ji and you are sharing. It has a direct connection with the first point, case management system. So the insisting on the filing of the hard copy, if we are moving towards a virtual environment, is it really of relevance? Because the court officer would tell, we say that we filed on 23rd. The court officer will say no, it is on 26th. It is the hard copy is filed on 26th. So I think if the focus is on using the technology, it should be not limited to the IPs
why
and the
insist on hard
petitioners. It should be for all. I mean, that is the limited point. I think this can be noted to the first point if you think it relevant.
I think the hard copy point is quite simple, and some NCLTs I know are insisting on hard copy. That should actually be avoided in the age of e-filing where everything works on electronic filing basis. Why insist on hard filing at all, hard copies at all? And I know some NCLTs are asking for that's, I think, administrative. It doesn't require any amendment to law. That's purely maybe a circular from the president of NCLT should probably help it.
Actually, it has become a prerogative of the judicial member.
So it shouldn't be that. It shouldn't be like.
But the point is they are not comfortable. The point is that the training part of it, there should be addressed to use virtual replies and to look at it, make it much more easier for them to look at what they want to look at. You know,
sir, I would say that if
they
were. Now, while the point is still relevant that some members may not be comfortable flipping through the soft copies, but perhaps in soft copies, the lot easier part would be that searching for the prayer part. You don't need to say, tell me which para. The system would search it. That's what I think. That's what intelligence anyway does. Where is the prayer part? Hit the prayer part. The system would automatically say it's para 6.37 of page number 230 of the petition. So flipping through evidences. Flipping through the prayer part, flipping through the evidences part also will perhaps be highly easy. And therefore, the reliance on hard copies will be extremely indicated. There are some people also wanting to contribute on that. And I'm hoping others also who are very, very well experienced.
One small point, sir. With regard to this point, I would request the judiciary to give their timelines rather than we telling them and then you do it. Let them give the timelines from their side so that it is easy for everybody to understand it. That is what is my point of view. With regard to this particular point, admission stage, they should tell, I will do it in 30 days. Yes, 30 days across the board, no matter whatever it is.
Surely, sir. Mr. Devan Sampath?
Sir, a small point, everything has to be IT enabled to increase the speed. And some acts like Evidence Act, NCLT rules, etc., which are said earlier, they need to be changed to enable technology to help the judicial processor. That is my small submission.
Surely, sir. Sikha, maybe you can move to the next point.
Next
Quite
amendment
simple,
relates to, it's a very simple proposal where we are looking to avoid conflicts of interest, where under section 10 applications, promoters now cannot propose IRPs. It would be only on the recommendation of IBC as in other cases, other OC cases. So any inputs here? I don't think, I think we should move ahead.
I have one small point. Why does a corporate debtor come for a resolution? To section 10 application, why does a corporate debtor come for a resolution? He wants to settle everything, right? And choice of an RP, if he is given that, then there is a responsibility also attached to the RP, right? It is not that he is not beyond the law. And choosing his person means he will be a person who will act according to what the things are in the situation, right? Asking someone, a third person, to come and act upon it, how it will serve his purpose? It is like any other application you are filing. Why does a corporate debtor come for a voluntary CRP? What is the necessity? Because he wants to settle everybody, right? With the right earnest. And choice of an RP, if it is taken away from him, then what will be the fate? That should be the point.
Because it's only the interim resolution professional that we're talking about, because the ultimate appointment has to be done by the committee of creditors anyway. Even for that interim 30 days time, the law wants to take away the right of the corporate debtor himself to propose an IRP on the ground that maybe such an IRP was chosen by the corporate debtor, while of course the RP has to be an independent professional. Merely that appointment was done by the corporate debtor cannot absolve me of my duty of independence, etc. So that the obligation to stay independent, to work as per law, still remains irrespective of who nominated the IRP. However, probably the feeling is that an IRP should also be nominated by the should be appointed by the AA based on the panel maintained by IBC, as is currently being done in cases where there is no such name given. There are several people who want to Sikha. You thought this will go uncontested, but I think there are many people.
Sentence I want to add here.
Yes,
if that is the case, CD cannot nominate somebody. Same applies to even for creditors as well as the OC also. Even the financial creditors also same thing applies. If they are proposing and that loyalty, all those things are same as loyalty to CD.
So maybe that, I think the moot point that they are building on is that loyalty to the promoters who are obviously the promoters of the corporate debtor versus loyalty to creditors.
Loyalty is loyalty. It cannot be different from CD to financial creditors.
I know. But you are loyal to the law. You cannot be loyal to any particular
that is the thing. In that case, in
theory,
all cases, only NCLT must appoint the IRP or RP or whoever it is.
In theory, I need to be loyal to the law. I cannot be loyal to any particular appointing body. But well, I think to an extent, there's the reality of life also we need to understand. If the IRP is on the brief of the corporate debtor, perhaps, I mean, there is a potential risk that he may not be able to do as well as one who is appointed by the adjudicator. But probably that's the thinking. I mean, I know that some of you have different thoughts on that. And Mr. Haridasu and Mr. Ravi Sitaraman also wanted to. Mr. Haridasu first.
Yeah, yes, sir. That point only I am putting forth. If that is the case, that CD cannot nominate, the same principle must apply to the financial creditors also. That's my viewpoint.
Right.
And or otherwise, in the law itself, some loopholes are there where it is possible for IRP to help somebody.
Mr. Ravi Sitaraman, sir?
Yeah, sir, Sitaraman here. Sir, as in voluntary liquidation, the companies used to appoint the liquidator. In case of this section 10 also, why not the CDB continue to allow appoint IRP? I don't think whether there is a certainty that independence will be sacrificed. I don't think so. There will be a better proposition if the CD himself appoints the IRP, because he will be interacting with the IRP and better things will come. Definitely, the outcome will be better.
Sikha, you were very wrong when you thought that this will go uncontested. You were very, very wrong. Raj Kamalji?
Yeah, as far as this proposed change is concerned, there will make no much difference, because once the IRP is appointed, the COC has their prerogative to change the IRP to RP. The only thing is for the 30 days, a person who is appointed by the promoter is looked from the magnifying glass by the creditors. But I don't think during the IRP period there is any much work to performed by the IRP. Basically, once the RP is
appointed, he is doing the main other things. So I don't think it is going to have any much impact on that.
IRP job is 30 din ka Raj.
Yeah. So that way doesn't have it. It will be only taking changes that COC. He is independent of a promoter. That doesn't make the difference. But
in any case, the filings under Section 10 have greatly come down. So let's also appreciate the data shows that initially when the code was promulgated, there were a lot of filings under Section 10, but over a period of time, Section 10 filings have greatly come because you know that you cannot be the acquirer. You will lose your rights under Section 29. So why would somebody at all move for insolvency? So self-filed insolvency applications have actually greatly come down. It might actually even be appropriate to take out this right altogether, maybe. But that's a distant thought. Anyone else? I think Mr. Kantipudi Venkatachala.
May I come in? See, the issue is we should understand the background to this change. The background of this change is basically the experience of NCLT on Section 10 applications, where they have seen collusions and the motive being to ensure that liquidation happens through this route rather than getting to a situation. Now, in fact, as you rightly said, the NCLTs have been discouraging many Section 10 applications and not allowing it to be admitted. So here also what we need to look at is that somewhere the integrity of the IPs are in question, and that also is the reason for this amendment to come. So we as IP community should ensure that our integrity is beyond question.
Sure, sir. Mr. Kantipudi Venkatraju, sir.
Same thing, sir. Same thing. What I would like to say is that there is every provision at any stage. The IRP appointed by CD can be negated and can be replaced by COC, as is being done in almost all the cases. Whenever Section 9 applications are there, the appointed IRPs are being replaced by bankers. So in that case, why to negate the right of the CD? Why to give it to the AA? Because as one of my friends was telling, RP only takes much load. No, it is not correct. The first 30 days, there is so much of load to be drawn by the IRP, like verification, paper publication, seizing of accounts, getting claims, and interacting with all, conducting first COC. So tracking the first track is the main track. After that, that can be used by RP also. But the first 30 days is very, very crucial statutorily. And after 30 days, you are simply removing that fellow who has done the much load so far. So that right of the CD need not be curtailed. The COC so desires to replace it, they can replace it with the second COC. Or after
that is there in the law anyways. That's currently also there.
That need not be
touched. There were a lot of concern about this proposal.
We cannot say that whoever is empaneled by the banks is so much loyal to the banks. In that case also there is some case of compromise.
Collusion.
That collusion also can be expected from the empaneled IPs because they are supposed to be loyal to the bank. Otherwise they won't give any assignment.
So the house is divided on this. So
no, house seems to be completely opposed to the idea. Anyways.
Okay.
Go ahead to the next
moving
one.
ahead. Next proposal relates to decriminalization of offences. As we understand, presently Section 235A calls for penalties, which again has to go through the route of the special code. Applications are to be filed by IPBI. Now the proposal is to decriminalize, basically convert penalties into fines, and the adjudication can now be taken care of by
fines into penalties.
Fines into penalties. Besides, one positive move, according to me, is there are instances of frivolous applications being filed under IBC. So now explicit powers are proposed to be given to adjudicating authority to impose penalties. The proposal also specifies minimum amount of penalties as well. Plus, with respect to malicious or fraudulent initiation of proceedings, while there are explicit provisions, but not for other offenses. For that also, there are proposals to specify penalties.
And then Section 29A disqualification as well.
Yes.
If the person has been, let's say, repeat offender is violated or he's been, let's say, penalized for offenses under IBC, at the discretion of the adjudicating body, he will be disqualified in terms of section 29A as well. So the basic idea of this is to move from a fine regime to a penalty regime as far as section 235A is concerned. Currently, the fine regime requires the IBBI to file a show cause and then move the matter to a criminal court, and then the criminal court proceedings take the case from there on. Now that process is even lengthier, much more longer than the IBC proceeding itself. For matters which were probably filed by IBBI in 2017, in some cases, I'm probably aware that even the hearings have not come still. So that's even because criminal courts are equally as burdened as NCLTs. And therefore, the idea essentially is to decriminalize and move from fine to penalty, like Companies Act, LLP Act, and several economic laws have done, and therefore replace not in all other sections, but only section 235A and the section dealing with frivolous and vexatious filing of applications. So that's sought to be replaced by penalties, and penalties can be imposed by adjudicating body with some basic adjudication principles laid in the regulations. So that's the proposal. Mr. Shivaraman, sir, you want to say something?
So basically the concern is, sorry, sir, please proceed.
My question is, does NCLT have the powers, inherent powers?
That is what I'm now granting.
That is what is being granted, sir. But one thing is, NCLT is not a criminal proceeding, right? It's a civil proceeding.
Which is why they are decriminalizing. Sir, I think they do two things. Number one, converting from fine to penalty. So the moment it converts from fine to penalty, it becomes an in-house adjudication mechanism, like in case of Companies Act. So number one, they're converting from fine to penalties. And number two, they're granting that power to the NCLT. So that's how it's, yeah, you're right that fine cannot be imposed by NCLT. NCLT is not a criminal court, but NCLT is definitely can impose penalties. That's the proposal.
That being the case, one more thing is, for how many applications, for example, under section 74, 76, how many things have happened in NCLT, sir? Nothing. Nothing has happened. Nothing. See, take the example of what to say, your section 19(2) application and your buffet transactions. How many judgments have come? How many people have been put forward? It is just to say, it's just an eyewash, I would rather say. It's just an eyewash, because really I am facing a lot of brunt on that. Personally, when things are to be completed, it has to be finalized. They take their own sweet time.
You're right, sir. I think 19/2 also will come under section 13 by section 235 only now. And I think that will also therefore get into a penalty regime rather than a fine regime.
If they don't do it, sir, it's a welcome sign, sir. It's a welcome sign. But one thing is, how far it is enforceable is the question. That is what is my point.
So I think we back on the point of delays. We're saying that essentially what is killing the system is the delays in the courts. And that is the biggest so-called elephant in the room that we need to tackle.
Address it. First, that is what I said. Ask NCLT to define the dates within which they will complete. Then all these things can work out, sir. I am definitely telling you, it will work out.
Correct, sir.
Okay. So going forward, many of the proposals relate to streamlining of CIRPs. Firstly, talking about fast-track resolution process. Although there are regulations in place, however, now we are talking about some out-of-court process where the FCs will take the charge, and things will require 66% of votes. IPs can be appointed directly by FCs, and FCs will only oversee the process. However, with respect to moratorium, which is optional, FCs can reach out to AA for declaring the same. So here the concern again is, if anyway we have to go to AA for the purpose of moratorium, the concerns of delay, as we talked about, will still remain. So anyway, the instances of FTRP are anyway not as popular as
currently FTRP has lost its meaning, Shikha, because
Correct.
the current notification talks about assets of up to rupees 1 crore.
Correct.
Whereas the threshold for filing insolvency is above rupees 1 crore. I think there's a clear conflict there. So fast track has lost its relevance with the current notification. So first of all, the government has the power to notify, and somehow they came with a notification of rupees 1. I think that notification also came some 6 years back.
Way back, yes.
So number one, they need to revise it up and revise it substantially, because I think even 100 crores would still be fine to think of fast track, or at least substantially upwards. And then the provision that this will be non-adjudicative except for the purpose of moratorium. So if you need to come to the adjudicating body for getting moratorium, one of the most important part of resolution process is moratorium. Moratorium is not ordered and creditors continue to bother the corporate debtor, then the whole purpose of insolvency is lost. So for the purpose of moratorium, you still need a statutory order, and therefore you need to come to NCLT. So while fast track can work, but the moratorium still is based on NCLT's discretion. There probably it might be an automated process, that if there's a fast track resolution, the financial creditors have anyway asked for a moratorium order, then without questioning any further, the NCLT should be willing to grant the moratorium. Then it would make fast track actually move on fast track. Otherwise, as I'm sure all of you would actually confirm that there's probably hardly any instance of a so-called fast track resolution at all.
In that case, the moratorium should have a time limit. Otherwise, the fast track, if doesn't come to the NCLT for approval, then the moratorium may be misused. So that way there should be a limitation for the moratorium in such cases.
The fast track anyway has to get completed within half of the timelines of the CIP process, I think. So I think the morat will also remain for that particular period only. Okay. Secondly, as we talked about PPACs, here also the idea is to extend the concept of PPACs. Presently, it's only for MSMEs. The idea is to extend to further categories of CD, and which are again yet to be prescribed. The proposal has not specified any sort of criteria. This basically depends on the central government, most probably. Plus, there are proposed amendments relating to declaration by CD with respect to existence of avoidance transactions, which may be omitted. So, Vinod, sir?
Yes, so I think this is something which was being talked about for a long time. Currently, pre-pack has really been a failure because it was intended only for MSMEs, and there also it requires those creditors to affirm the pre-pack resolution who are actually getting a haircut. We're expecting somebody whose claim is suffering a haircut to actually go and vote in favor of the resolution. So in any case, there were only 2 instances of pre-pack resolution so far, and therefore it's been almost like a failure. So the fact that pre-pack may extend to non-MSMEs of such categories or such types as IBBA or central government may perhaps lay down, that is certainly, I would say, expanding the scope of pre-pack. However, the procedural part is still laden with multiple approvals, a special resolution, then 2-stage process to go to adjudicating body, etc. So if anything which is asking the corporate debtor or the creditors to go to NCLT, the moment you talk about reaching out to NCLT, it takes time. I think all of us are, time and again we're talking about the moment you go to NCLT is the courtrooms, and then you're talking about enormous amount of time being lost there. If you're talking about 2-stage approval, then it makes it even more cumbersome. So if actually the pre-pack has to work, pre-pack is basically what? Pre-agreed by creditors. It's almost like an out-of-court agreement. It's sort of an OTS, sort of, let's say, creditors' own settlement. The creditors are coming to court merely for getting the seal of approval and to make it mandatory for everyone. So if that's the idea of a pre-pack, here it should actually move much faster, and a single window clearance by NCLT is all that should suffice, instead of asking the process to go to NCLT on multiple occasions. That's what my take would be, but if others have any suggestions to make on that.
I cannot see any raised hands, sir. So I would rather proceed. The next proposal relates to insolvency of real estate projects. As in, instead of looking at the entire real estate company, we will now look at real estate projects. So we'll go by insolvency resolution project wise rather than entity wise. For example, it's here. When an application is filed to initiate the CIRP against CD being promoter of a real estate project, A at its discretion admit the case but apply the CIRP provisions only to such projects which have defaulted. Additionally, transfer of ownership and possession during CIRP to the allottees with the consent of COC is proposed. This to our mind also should be a welcome move. Any contrary views? Yes, Maheshi.
This is workable only if we have a project-wise balance sheet, because otherwise, how you are going to identify the liabilities and constitute the COC and other things? Because normally the corporate debtor has common liabilities, loans, etc., which are spread across the projects and which may not be correlated to a particular project as such. So practically, this may be difficult to implement. Although it's a good suggestion, but from the practical
implementation might have practical considerations into separation of liabilities.
It will create a lot of Pandora box, because again you need to get your financials prepared for a project, get it audited, justify that this belongs to this project only. There are no liabilities or things coming from the other projects. So like that.
It's the same problem that would arise for the partial resolution as well.
Yes,
it's the same issue. Partial resolution as is proposed, and you're coming to the next slide perhaps. So in all partial resolutions, as also in case of real estate projects, it works only if there are project related liabilities. If there are corporate liabilities which share the assets of multiple projects under a common entity, then this idea would never work.
Vinodji?
Yes, Ravindra sir.
Yeah, see, I fully endorse the view of, I mean, I did not hear
Mr.
the
Mahesh
name
Mittal.
of the
Mr. Mahesh
Maheshji. See, but it is normally what happens in these real estate projects is that once the first money comes for the first project, it is not necessarily it is utilized only for the first project. Most of the times, the money which comes from the first project is utilized for the purchase of land for the second, third, or fourth or fifth project. So, this amendment I have serious concern. Even I had concerns even for the NCLAT and NCLT orders, which were in my view not appropriate for the reason what Maheshji told and whatever I am sharing now. So making an amendment in the law, I have serious concerns, because it would give easy way for the fraudulent promoters to see that the home buyers are put to more difficulty, and it is quite possible that the money which is collected for the first and second project, or the third and fourth project, is invested on the first project, and the money really belongs. I mean, the first project also home buyers also would have invested the money, but this first project gets completed, and third and fourth project home buyers may be put to a lot of difficulty. So, and this has a concern. The same thing I have a concern regarding the handing over of the completed flats by the RP with the approval of the COC. I have a serious concern connected with that also, because I doubt whether there is any real estate player who is keeping track of the inflow and outflow of the money project-wise, though I think it is expected as per the RERA, if I am not mistaken. So this is my serious concern, and I do endorse your view regarding the part resolution. That is not a real good idea. I think it should be, it should not be made as a law. If there is a specific cases or something, then it gets handled in the existing way. Even as of now, I understand that there are multiple resolutions for a CD, not too many, but which have the assent of the adjudicating authority after the adjudicating authority has been convinced about it. I think it should not be a very general law when it comes to the aspects what we have discussed. That is my humble submission.
With regard to the board of directors, suspension of both the board of directors, how it is going to be done for the particular project and company as a whole, that is also a question needs to be answered here. Secondly, wherever there are multiple projects and one of the project is in the problem, then in that case the company as a whole can go for the CIRP, and the lenders of the projects which doesn't have any default and all those things, they may continue with the projects, and the project wise resolution plan can be there, and for a particular project the resolution plan can be there, and for the other projects that may continue, and the COC should have a decide in such a way. Then in segmentation of COC for the project wise can be done, but the CRP process needs to be taken forward for a company as a whole. That is what I think. But it will be very difficult to implement the project wise CRP.
Actually, sir. Hello.
Sir, my
Yes, sir.
basic question
Yes,
is.
sir, you are audible. Anil sir, you are
Hello?
audible.
Hello?
Anil sir, you are audible.
Sir, actually, we are talking about this project that the CRP based on the project is going on. You know, it is not possible in a sad. It is wasting of time, and it is putting the responsibility on the shoulder of the CI, RP or IRP, because he don't have the, he can't manage the fund, and he have no authority. Because every company who have 2 or 3 or 4 projects, so based on their inflow outflow, they are controlling the project. But if he have no authority to control that fund, how he will manage? Otherwise, lot of litigation, lot of discipline action on the RP, IRP. You do this, you can't do this, you do not this, you don't know this, like that. And if you have no full authority or authority controlling, so you are not able to manage this project wise. It is not possible.
Mr. Shivaraman, sir?
My basic question is, are we going to change the preamble?
Why did you think so, sir?
The preamble, sir. The preamble. Are we going to change
The preamble of the law.
preamble?
What exactly is conflicting in the preamble with this proposal?
It says the resolution of a corporate debtor.
So it's still the same. I mean, they are not saying CRP of the project. They're talking about CRP of the corporate debtor. That is the company having multiple projects. Let's say one company has 5 projects and the company is default. The CRP will be that of the company. However, resolution will be possible for real estate projects. In other words, if one project, let's say, is still good, other projects are facing an issue, the project which is good will be allowed to, let's say,
Continue at its own pace.
So while we'll still need to see the details, and probably there's similar proposal for partial resolution in the next slide as well. So the thought process has been going for quite some time that it's possible to do a partial or fractional resolution, while though the default is that of the company. But resolving the company does not have to mean resolving all the projects of the company in one single go. It may be project-wise resolution. That's probably the idea, though the details need to be seen as we get to see the fine print of the law. Mr. MG, sir.
Thanks, sir. I welcome this move actually, because I closely interact more with real estate projects. One of the, of course, there is a regulation which is going to follow with the amendment in the act. That's what I have heard from IBBA. and those fine prints will be available there. Especially, how do you constitute a committee of creditor? See, in case of a corporate debt is there, and then see if it is only a project, and if at all you can distinguish the liability towards the project, you can always allocate that particular liability towards that COC, right? And otherwise, what happens is that these are all the things, the fine prints already is under working by IBVI. That is one. But the reality is that this is very much required, sir. I know a lot of real estate companies which are all having 4 or 5 projects, and all these projects individually has got shortfall also. And if at all you don't do this resolution project-wise, probably the good one or revivable one cannot see the light at all, because everything will stop, right? I'm really welcoming this.
Thank you for making that point. And just wanted to supplement by saying that there's a well-known practice called project finance. Project finance, the whole definition of project finance is that the lender has looked at, number one, assets of the project. The lender has security interest on the assets of the project. And primarily the cash flows from the project will go to repay the lender. That's a very definition of project finance under RBI's regulation itself. And mostly in case of project finance, the lender will have an escrow mechanism whereby the cash flows from sale of units or apartments from the project will go through a particular escrow to the lenders in that project. That would mean there is no commingling of cash flows across project. That's the way real estate finance or project finance typically works. So some of you are saying that the cash flows are still commingled. Mostly in practice, they're not commingled, because the project financier will ensure that the cash flows of the project are first dedicated to make payment to him rather than go to other creditors. Of course, the operational cost of the project have to be taken care of, but there is an escrow right over the cash flows from the project.
I just missed to add to one point. Sure. After the RERA, now all the projects are having individual accounts. And even the collections are getting deposited there. There is an escrow account. Only 30%, that is the margin or whatever it is, 20 or 30%, can be only siphoned off by the promoters. Of course, we can argue that a lot of malpractices may be there, but in reality, the project-wise accounting is available. That's what I could say.
Yes. I augment what Mr. MD says. That is there. RERA, 70% you have to utilize for the project, 30% you can utilize it for some other purpose. It is based on 2 certificates. One is the Chartered Engineer certificate and a Chartered Accountant certificate, as to the completion and to the funds utilization. If that is strengthened, then this can happen, or otherwise no.
And RERA is currently applicable in most of the relevant states. It's a state matter though, but well, some states have not implemented still, but nevertheless, most of the states have actually implemented. Mr. Devang Sampath and Mr. Devarajan Navansa.
So since RERA has been mentioned, now if you are going for project-wise insolvency, they say the accounts is available. What is taxation impact of that particular project? What about the guarantees of that particular project? In RERA, the same tower also can be in 4 phases. If one phase is registered, what about the land for other 3 phases? Maybe, as I said, what about the taxation? Then they talk about the 2 accounts. Maybe they're talking about Form 1, Form 2, Form 3, Form 5, etc. Now 30% goes to a corporate account, 70% goes to specific account. What about the 30% amount that is gone elsewhere? There are many such issues. And maybe in my humble understanding, yes, this is a very enabling and welcome gesture by regulators, but a project or maybe industry specific resolution is not an ideal thing in my limited humble understanding. A general law is good enough to deal with all situations if it is well implemented and gives a freedom to create in a way any individual IP wants to do with committee of creditors and other applicants. Going for specific situations, exceptions, etc., would create more problems than solutions. So these are some just minor points which are pointed on this project resolution. Yes, we understand that real estate problems are very big problems. Home buyers are involved. But maybe we are getting into a situation where we are trying to find a solution which itself is creating other problems.
Mr. Devarajan, sir?
See, the point I want to raise is that somebody talked about the preamble in this context. Now, when an admission happens, the admission of the CD happens into CR. You say project-wise resolution. Now, the challenge for the RP there, he is not able to give the other 5. Suppose there are 10 projects, 2 is under CRP. The rest of the 8 of the projects, the promoter is not permitted to deal with it independently. The RP is there in the picture. So the RP may not per se be capable to handle 8 projects. He will need the promoter support. The promoter basically is in difficulties in this particular case. So when we are talking about project-wise CARP, what is the modality? Because the promoter should not be put into a situation where he has to, take the permission of RP for every small things in the other projects. That defeats the very purpose of having a project-wise resolution. There needs to be a solution to this. But this has created a lot of problems in many cases where project-wise CRP has been taken. This is a very practical kind of a situation, which also arises from the preamble of the code, which talks about the CD getting into CRP. So there needs to be some amendment or some carving out kind of a situation where the project assets and liabilities can be segregated and handed over to the RP.
That's a very important part.
Looked at.
The ring fencing of the assets of the particular project and segregation of liabilities so as to keep the working of the project distinct from that of the corporate. We're not talking about default by the entity, we're talking about default by particular project. So that's a very important narrative. And these all things normally are a part of the narrative, but the narrative has to be amply clear and has to think of all the details because we're talking about default by a company, though pertaining to a particular project. So it's not a corporate level insolvency, talking about a project level insolvency. It's a novel concept. I think the next slide, which is currently on screen, also talks about something similar. And therefore, Sikha, we might probably club the two discussions because here also talking about a multiple,
multiple resolution plans for the same CD.
But there the presumption is that the multiple businesses are all insolvent. In case of real estate, we're talking about some projects being bad, others being good.
Correct.
And therefore resolution only for the bad one, leaving the good ones still in the control of the corporate debtor. So that narrative will still have to come clearly from the rules, and these are normally part of the rules. So I'm guessing that it would, and in any case, I think we can build up our recommendations so that while drafting the rules, IBBA can take care of some of them. Points very well made by all the participants. Mr. Shivaraman sir, did you want to add something further or? You are muted, sir. You are on mute, sir.
So should.
No, you are still on mute.
Sorry. What I mean to say is that the books of accounts of that project are clearly decipherable with all liabilities and assets being clearly demarcated. Then the resolution can happen, or otherwise, no, it can never happen.
Perfect.
Because for the simple reason being, there is always a diversion of funds from one to the other.
You're right, sir. I think those narratives have to be there in the subordinate.
It has to be very clear-cut demarcation.
Sure. I think that's a very important. I think the participants have given extremely rich contributions to what should be there in the subordinate law so that the intent of this particular provision is not frustrated by lack of details. Details are needed here. And that's very well made point. Sikha, I think the multiple resolutions will probably be somewhat similar.
Yes.
Yeah, you can maybe briefly introduce the,
So
the
briefly
concept.
I'm just briefly introducing it. So CIP regulations already have certain bits and parts of similar such stuff where they're talking about piecemeal resolution. We have regulation 36B and 37(1)M, where the resolution plan may actually provide for sale of one or more of the assets of the CD to one or more successful RAs and manner of dealing with the remaining assets. Now the proposal is to enable resolution of individual or collective assets of the CD in one or more resolution plans, but there is a rider that at least one of the plans should provide for insolvency resolution of the CD as a going concern. Now, as and when COC approves any of these multiple plans, the plan goes to AA for approval. The AA once approves it, it shall be implemented pending approval of other plans. So we will not stop for any particular plan. The plan, one plan once gets approved, it goes into implementation mode, and the rest plans will follow the first plan. So this is how the proposal looks like.
Serial resolution. Resolve
Correct.
one
It's
episode.
serial resolution. Correct.
Resolve one episode, then wait for the next one, then resolve the second one, wait for the third one. So
Yes.
that idea is quite noble. Once again, a lot of it is a matter of detail once again, because you're talking about the good one has gone off. Now the good one actually could be the cash cow. Therefore, what remains is extremely unattractive. So the essential question is once again, and I think the next slide will have those concerns. If you can maybe just scroll down.
Yes.
So the economic premise of a serial or multiple of fractional resolution always is whether the sum of the parts, you can probably see it on the right hand side in the equation, sum of the parts, that is everything put together, versus the sum of the parts separate. Sum of the parts, that is one ABC all put together, or A plus B plus C. If the sum of the parts, that is individually, leads to a better economic value than the entire part put together. And I'm sure you'll all agree that conglomerates are quite a good, I mean, there's quite a good proposition. A lot of companies actually are conglomerates. But when things go bad, like one bad apple spoiling the rest of the apples in the basket, similarly, one bad entity might actually kill the value of the rest of the entities. So why should resolution actually necessarily insist on all the apples in the basket being bought by the acquirer in one go? There might be multiple buyers for multiple apples, so to say. There might be multiple buyers for multiple undertakings. So as far as going concern is concerned, going concern is the presumption. Because during insolvency, we presume that the entity in question is a going concern. It becomes a gone concern only in case of liquidation. So that's the presumption anyway. So that condition is easily satisfied. But the question is, whose approval are we asking for? If you're talking about entity that is not, I mean, enterprise-wide, not entity-wise. If you think of entity as the legal entity and various enterprises or various undertakings within the entity, the equivalent would be one of a demerger. One entity is getting demerged, remaining undertakings still remain within the entity. So you're talking about one entity getting moved out of the entity by way of resolution, remaining undertakings still staying with the entity. Question is, will the creditors of the remaining ones happily approve the going out of the business? Creditors probably would be, they might either be entity-wide creditors, there might be some segmental creditors as well, undertaking-based creditors as well. So question of COC's concurrence will still remain a challenge, but that's where, as the Supreme Court says, the commercial wisdom or the lack of it of the COC would have its overwhelming sweep. So if the creditors in their so-called supreme commercial wisdom want to approve the resolution of one single undertaking while the rest are still waiting to find a shooter, I think that makes commercial sense. In many cases, it might find a lot of commercial liquidation. We always do it, sell entities in bits and pieces. So if in liquidation we can sell the entity in bits and pieces, why can't we do it in resolution? That's, as an idea, perfectly seemingly okay. I think people still would like to express the thoughts. So Mr. Devang Sampath.
Sir, I'm aware of couple of resolutions which have already happened in this manner in the existing framework itself. So why a new framework is required is something which maybe if you could help me to understand, sir.
I think in many of these proposals, what is already there in regulations is now being brought in the law. Because quite often people will say subordinate law has it, but where is the substantive law having it? So they are wanting to introduce what is already there either in practice or in the regulations. They want to codify in the law.
Thank you, sir.
Shivraman, sir.
So first and foremost question which is to be answered is, how many entities are there which are good and which are bad within those framework. And for example, if you find a resolution to one of the projects, and CRP is a time-bound process of 330 days maximum, how are we going to handle that point of view? If one within the 330 days gets over, and if the other part of the entity goes into liquidation, how are you going to handle such type of a situation? When liquidation is of a corporate debtor, not as an entity as such, how are we going to address that point of view? That should be very clear in this law. If such a situation happens, what has gone by has gone, other part will be the part of the liquidation. That should be the point which should be very clearly deciphered in the law.
I think that should be implicit, because if resolution works for one entity or one undertaking, the remaining undertakings don't find a shooter, don't find a buyer, it then moves into liquidation. That could probably be the idea. You're right, that should be explicit. Explicitly come in the details.
Yes.
Right. Ashika, we might maybe move to the next one.
Yes,
this one is another
interesting proposition. So basically, till now, the resolution plan provides for all the intricacies, including what amount the RA intends to provide, plus in what manner it wants to distribute the proceeds, the resolution amount. Now, basically, we are seeing distribution as a separate process from resolution. Resolution can take its resolution gets decided, and distribution can take its own course, basically. So the RA will give the resolution amount, but distribution now COC can take care separately. That's the proposal.
So the proposal basically, the RA will indicate how much I'm willing to pay.
Yes.
So I'll pay 200 crores. Now 200 crores currently says I'll pay 150 crores to FCs, I'll pay 30 crores to OCs, I'll pay 5 crores to government, I'll pay 10 crores to workers. So he also gives the allocation of what he pays to who.
Correct.
Now what is expected is he'll say this is all that I would pay, and the distribution is left to the COC.
No, so maybe we can club this proposal with the waterfall proposal also.
Correct.
Because when we are talking about distribution, waterfall becomes important. In case of liquidation, we have a identified waterfall, which is quite obvious. So in cases of resolution, going by the vertical comparison approach, we would of course have followed section 53. However, there have been debates around it. So therefore, what the proposal is to introduce some sort of waterfall in case of CIRP, which is again aligned with section 53, which again we see is getting compact pursuant to this proposal. So seemingly, to my mind, so a good move.
Yeah, but let's hear from.
Yeah, let's see.
Sir, first of all, this thought process has come where the concept of equitable distribution in some of the Supreme Court cases which has happened. That is the basis on which this law is coming up. Now, leaving it to the COC members to decide as to what the payments are to be made. Will there not be a fight within the COC where operational creditors are not part of the COC?
No, so that's what I understand is this provision is supplemented by the provision for waterfall, where they are now actually laying down the rules of distribution even in case of resolution. So the space for subjectivity probably would get eased out. That's what I understand.
The counterpoint, Sikha, as Mr. Shivaraman sir has already made out, is that, see, resolution applicant is the one who has to carry the business forward.
Correct.
He has to carry the entity from here on. So he would need whose support? He will need the support of the creditors.
Workmen.
He will need the support of suppliers, vendors, employees,
everyone.
Workers, everyone. So he'll say if I leave it to the COC, which is consisting of just one class, financial creditors, do we expect the financial creditors to keep money aside for the workmen, to keep money aside for the employees, to keep money aside for others? Because what matters is my self-interest. Every creditor is overwhelmingly driven, and I think rightly so, by his own interest. He will not be looking at the interest of the RA. So RA is the one who can probably see the futuristic interest of the entity better than the COC. COC is obviously dictated by their own self-interest. So how does one expect or perhaps in that case, the RA would probably have to say that this is something that I'm leaving to discretion of COC, and this is something that I will pay as a part of my own discretion, perhaps something like that.
Perhaps something like that. Because he has to keep everyone happy, right? get the wheel moving.
But
Yeah,
let's hear from Mr. Devaraj and Raman sir.
But one thing is,
see, you know,
the point is
what is said here to an extent overlaps with the current mechanism of resolution under CRP, where an RA is permitted to sell some assets and retain other and give a resolution plan. Now, if you are saying that you will do a separate resolution for the undertaking separately, there is a plethora of changes. I think, Mr. Vinod Kothari, you know better, has to be done right from stamp pack to various other places to make it happen economically. Otherwise, you will have to demerge the entity, put it in a separate company, and you know the taxation issues coming there. So the point here is that, as you rightly said earlier, unless the narrative comes in, you are not clear how it will work. Now, the point is that if suppose I am an RA, I have a corporate debtor where I am submitting a plan. I may possibly be interested in 2 units out of 5 they have, or 5 businesses they have. I will then say that what I could realize out of the other 3 businesses. Now, the value maximization for me happens in the other 3 businesses, provided I give a comprehensive settlement to the creditors of the entire CD. Then I'll be able to fetch a better value for that, and I will accordingly put an enterprise value and bid for it. Don't you think that's a better option than doing something like this? But I don't see, I am not able to see clear advantage in doing that. I see a lot of confusions going forward in this. Possibly I may not be able to visualize all the confusions, but there are apparent confusions that you can see could crop up. And if you see your slide, the last portion you're saying about whenever finalized and approved by the COC, the resolution plans, the scheme of distribution, as the case may be, shall be placed before the AA. Now, what is the role of AA here again? Now, on one hand, the distribution has to be done by COC. The AA will evaluate whether it is equitable, or how do you ensure that the mandatory contents of the plan, the section 32 read with section 34, and I think regulation 39 is complied with in such a case? Or they may have to make changes there also. I mean, I'm just thinking aloud on all this. That's I have no solutions, but I'm just thinking aloud. Thanks.
Right. Okay. On the, I think Sikha, we talked about the waterfall already. And maybe I think just move on to the Swiss challenge thing. This, I'm sure, as many of you would have already seen, that a lot of major resolutions, the Swiss challenge mechanism is being used. Every day in the financial press today, you're hearing about one leading matter going in Mumbai, where Swiss challenge is already under challenge. But now the code seeks to mandate that instead of a plain auction, the Swiss challenge method would be mandatorily one of the options that can be used for the resolution plans. Mr. Sushant Das. Mr. Das,
hello. Yeah, good afternoon. Good afternoon, everyone. This is just with respect to my inputs in the previous slides from 9.4 to 9.6 onwards, where we were talking about the distinction between the resolution plan and the distribution methods. So what is our view in this? Actually, there is major disputes are coming in the distributions parts. And because of this, distribution parts are getting delayed because of filing of A. And so the SRA, actually, they are not able to take over the CD. So what is our thought process was, we will divide them. So once the resolution plan is approved, so let the SRA pays the money. Let the company be handed over to the SRA. However, the distribution, if there is dispute, it will be kept in the escrow account or something, some kind of mechanism, so that once the dispute is settled, then it will be distributed among them. So this was the plain vanilla thought. From that thought only it has come.
Thank you for clarifying that. And I think personally, I would say it's a welcome move, because there is no reason to keep the handover of the unit pending till disputes about distribution are taken care of. Of course, distribution plan itself goes to adjudicating body, and adjudicating body might therefore take care of the equity involved there.
Exactly. And when we are just now, as we are this waterfall mechanism also, again, we are redefining. So it will be a straitjacket formula. And
Wonderful.
apart from that, when the some points are actually come that how the RA will satisfy the creditors as per their need. So that option also we are keeping it open if COC wants, so they can give some incentives to the employees if they want to keep those employees when it is a going concern. So that option will be there. So with that thought, it has come. So,
but I think, Sushanta sir, the basic idea is that a lot of detailing will probably have to be there in the subordinate law, because the statute simply
that's true.
Delineates the outer periphery, but within that, whole lot of work still may be done. I think the contributions today could be helpful when we get into
the
rulemaking.
Definitely. Thank you.
So next is again monitoring the implementation of resolution plan. This is a practice which we see even today. Resolution plans for the purpose of at the time of implementation, we generally see a monitoring committee taking care of the implementation of the resolution plan. The law basically wants to codify it. Proposal is to codify this, and basically it wants to mandate that a monitoring committee should be constituted for monitoring and supervising the implementation of the resolution plan. It doesn't say anything about the kind of constituents of this monitoring committee as of now. So maybe any inputs on that?
Or maybe it's left to the COC.
Yeah. As of now, generally we see that there are representatives of resolution applicant, the RP himself, and some representatives from the side of COC. So
I think that's how it should be, probably RA and the COC put together.
Okay, the next is A is empowered to cure curable defects in resolution plan. There have been rulings where the powers of AA were curbed for at the time of modification of resolution plan. The A was limited at that this A was debarred from making modification to the resolution plan. Now the proposal talks about that A can send the resolution back to COC to cure certain curable defects. The proposal doesn't talk about what kind of curable defects the proposal is talking about, and what kind of cure the proposal is talking about. So
I mean, in matter of principle, this is once again perhaps undisputable, but you're right. The whole issue will be what are the curable defects, so to say, because if the COC sends it back, like in case of JETEV is asking the resolution applicant to increase the amount, then we are once again, I mean, we are then
so if
asking
it goes
the
into
COC,
the substantive part of the plan, it becomes a problem.
Commercial wisdom, so to say, the Supreme Court's famous expression. If it gets into questions of commercial wisdom, that might be highly uncommercial and unwise. Shriram sir.
So first and foremost thing is all adjudicating authorities have only one point of contention, is that equitable distribution. Even though Supreme Court ruling is there, everything is there. COC approval is there, everything is there. Every plan which is minutely being discussed by the adjudicating authority is that, have you given equitable distribution to all the parties? And questions have been raised with regard to operational creditors who are government authorities, for example, Noida Authority. Very simple, land owning authority. How the treatment has been given to them. Even though they are considered to be operational creditors, they are being questioned and they are being asked, why can you not go for a renegotiation with the Noida Authority to make the plan admissible? These are things which are required to be more clear. If you give it to the adjudicating authority, the adjudicating authority will start questioning the COC approval. Very clear, sir.
If the provisions, the waterfall is made a part of the CRP provisions as well, will it help? Because then the COC has lesser of what do you call scope for flexibility or discretion.
Sir, my simple suggestion would be, for example, if there is a plan of 100 crores and if the liabilities are to be given, it can be, what to say, percentage method can be adopted and given to each and every player. so that it solves all the problems. Where the equitable distribution happens. There should be clear-cut understanding. You cannot live it to the limbs and fancies of someone and then question that limbs and fancies. Once it has been decided, it is decided. You say one side.
If the equity of distribution is made a part of the waterfall,
that will
currently we're referring to liquidation value and we're referring back to section 53. Liquidation value itself is contentious based on what the valuation would be. But I know that writing down the waterfall during resolution will even be tougher than writing waterfall during liquidation. The liquidation, we know what the values have been realized, but we can actually post facto verify the values. In CRP, the values are still to be discovered. So therefore, writing waterfall in resolution will be quite a challenging task, and I'm hoping that Mr. Shantadas will be able to pick up some thoughts from these discussions. But it will be very important because you are right, Sivaraman sir is very right that in wherever the resolution plan has been examined or questioned by the adjudicating bodies, the prime stress is the so-called equity of distribution. And equity, if that's made a part of the law, at as detailed principles as possibly could be there in the law, leaving less scope for discretion, that would probably help to an extent. Mr. Ravindra sir?
That is what is my,
that
is what is my point, sir.
Yeah, see, Vinodji, I think you have covered the point in some ways. I just want to stress regarding leaving the distribution to the creditors, and it is a separate process. I think even if there is a very specified way of, I would say there would be one section 53 for liquidation value and one section 53 B or whatever you call it, 53 amended for the what do you call
CRP.
Anything value over the liquidation value. Let us take it is not necessary that all resolution plan needs to be over and above the liquidation value, right? It can be less also. There are decided cases. What happens, what can happen is that again, the operational creditors may get zero value, whereas if that is a industrial product which depends on 2, 3, 4 suppliers, and if their requirement are not met, would the corporate debtor be able to get the supplies at a later point without getting even 1 rupee for the past supplies? And in my view, that segregating approval of plan and the distribution could lead to more litigation. I'll pick up the point from you regarding the liquidation value. If you are thinking of very standard formula for distribution, I think in the next 2-3 years, you can see more litigation related to the valuation than anything else. That is my respectful submission. In my view, there shouldn't be combined, and we shouldn't make what you call a very standard formula for the distribution. I think this thinking of this change, it could have, though the intention is that to meet the objective of maximization with equity in the time-bound manner, but we may not achieve the time-bound manner, and it may get affected because of more litigation than now we have more to do with the valuation. That is my respectful submission.
I think the point is valid. And sir, just 1 second, and Mr. Shantadas.
Sir, I'm Suhasini here. I'm from Easy Resolve.
Just give me a minute to just make a point that when the COC votes on the resolution plan in the so-called, let's say, segregation of resolution plan and distribution thereof, when the COC is voting on resolution plan, are we saying that they are not voting on the distribution? If the resolution and distribution are segregated, are we expecting the COC to first vote on the resolution and then maybe separately vote on the distribution? Because that would then, I mean, if we linking those two, then maybe if the resolution plan is approved, distribution is not approved. Are we therefore saying that the resolution can go ahead even if the distribution still remains undecided because the COC has not been able to either they don't approve it at all or they don't approve. They still want to take time for the I think it's a complex question, and I'm sure that a lot of further work might be needed to actually come to a meaningful solution on that. Mr. Shivaraman sir, did you want to add something?
So first of all, does the resolution applicant come with the hard cash to take the company? He doesn't. He gives it over a staggered period of time, right? So how the distribution will happen? For example, if he is telling the financial creditor, I will pay within the next period of 6 months or 1 year. And up till that time, the documents will be available with you. That is how it is being done. It is not cash and carry business, right? You put the cash and then you take the business out and the distribution is done by the COC. It can never happen like that, sir. Very clear. The distribution has to happen along with the approval of the resolution plan. It should go hand in hand, or otherwise it will not. It will create a Pandora's box.
Suhasini,
this
madam?
is my humble submission.
Right, sir. Suhasini, madam?
Sir, even I have the same similar views. I was about to discuss on the next point, sir, which you have mentioned about the curable defects in the resolution plan. By AA. Yeah, this AA empowered to cure defects in resolution plan. You see, this is proposed. But in one of our cases in Hyderabad NCLT, the resolution plan was submitted last year. Now, the NCLT has given back the resolution plan, asking the RA to cure the defects in the plan and again place it before the COC, take their approval and file a RP to file a fresh IA for adjudication of the modified plan.
Right, ma'am. Mr. MD, sir?
Oh, I'm audible, sir.
You are, sir. Very good.
Yeah. Sir, I got a small difference in view. This is a welcome move, sir. Why I'm saying is that, see how much has to be paid by the RA and when they will pay, everything is part of the resolution plan, right? Maybe after 6 months, after 1 year, whatever it is. It is not a cash and carry business, as rightly pointed out by Mr. Sivaram, right? But the reality is that if there are, say, for an example, equal stakeholder in the COC, 2 banks are there, right? The distribution is an activity within the COC, right? So resolution is the prime activity which should be segregated, and resolution means you are reviving the corporate. And proceeds, when it is coming, how to distribute, how to divide between us in the COC, that should not form part of the discussion while we are discussing thoroughly about the resolution plan. In my view, I go with what is being suggested, and this amendment is a welcome suggestion in my view.
Right, sir. Shikha, maybe you can move.
Yes.
Yeah, this part is very important.
This again is very important. Here, as Vinod sir earlier said, that in presently liquidation is an irreversible process. Once CRP fails, the CD gets into liquidation. It cannot come out of it. The only probable solutions are sale as a going concern, and in few cases schemes of arrangement. However, what is now proposed is, even after, say, the entity has slipped into liquidation and is proposed to be, say, continued as a going concern, it can still be reinstated into CIRP. So even before initiation of liquidation, this might be possible. But then again, we are talking about a discretion of adjudicating authority in this regard. So that is one thing. Will it again give rise to concerns as to timeliness? Are we only repeating the process again and again with no fruitful results, or is it a good alternative? That's the question.
Shikha, I just want to say that there is a word called zombie entities, and this word wasn't there in the banker's dictionary for forever. This was introduced Mr. Ram Rajan, of course, has talked about it. Before that, one of the earlier executive directors of RBI had talked about this word.
Okay.
And this word thereafter has become part of the banker's vocabulary. Zombie entities. Entities dead. And but it's still feeding a dead entity with money. And it's keeping it alive some way. So the entity did not meet resolution within the timelines. The entity therefore went into liquidation. And the creditors now want to spur it back into life by bringing it back into CRP. So I think while there might going concern sale and liquidation is enabled by the regulations now, even the Supreme Court talked about that in some rulings. But the question basically is that if we say resolution is time bound, we're bringing it with a threat that if you don't decide within 9 months, in that case, you're slipping into liquidation. And once you go over there, it's irreversible. It's almost like death, corporate death. But after signing on corporate death or death warrant, so to say, and then saying the company will still live because it's still a going concern and therefore the creditors wanted to remain alive. Well, that is, I mean, while in the erstwhile winding up regime, there have been cases of revival of entities into winding up. But the whole stress of the loan timeliness, I'm not sure what will happen to the challenge of time if we were to keep the possibility of bringing it back to resolution once again. But let's hear from others, Mr. Ravindra Belayor and Mr. M.G. Chandrasekharan, both were wanting to say something. Mr. Ravindra.
Yeah, see, I read this as there are 1 or 2 cases where the implementation of the CIRP did not happen. I think it is Tirupati or something, some company's name. In that case, when the creditors moved an application for reinstatement, or I'm not sure whether this is the innovative idea of the creditor or the adjudicating authority, the say, for example, after the CIRP, after the resolution plan was approved, and then within 4 or 5 months, they did not implement the plan. Then again, it was CIRP was ordered after certain months or something. I mean, this is what I think could be the source for this amendment. Because I am aware of one case, I'm talking from the public domain, I'm not privy to the internal aspects. A company called Scott Garments, it is in the same process. In fact, Mr. Sushant Das is there. Maybe IBPI could investigate the matter from end to end in case of Scott Garments, because it has more than 2.5 years that the resolution plan has been approved and no implementation has happened. And now the creditor is requesting for the CIR to be initiated again. There would be huge number of issues involved. Who would pay the liability between the point of the order of the NCLT and till the order of the CIRP, whether it is in liquidation or in CIRP? And if he has made gains or incurred losses, who would bear it? And if there are many machineries, equipments and have gone away, what would be the case? For example, I know for sure, based on the records on the public domain, this particular Scott Garment, I mean, we don't take the name, this particular company was, resolution plan was something like 180 crores and only 10 crores or 15 crores was paid. And the SRA is enjoying the facility for the last 2.5 years. And now you start the CIRP again. How do you manage the claims? What would happen? I mean, it would open Pandora's box, and I more tend to agree to Vinodji in some sense. He said that we already have compromise and arrangement. You can sell the company in liquidation as a going concern. And why we need to have this life after death, that is one point. Second related point is there is an absolute requirement for a time-bound decision in case the implementation of the plan does not happen. If the implementation of the plan does not happen and the creditor moves an application, it needs to be decided by within 15 days or 30 days. It is more critical. Otherwise, you are not bringing the discipline in the system. It can be that anybody can give the resolution plan and take the system for a ride. So I strongly urge, since Sushant ji is there, to have a proper case study of the company what I share, because I am not privy to many of the aspects. I am privy only to the orders which are on the NCLT, this one. And understand the challenges and link it with this life after death of the CIRPs, and timely decisions regarding the non-implementation of the plan, which is highly needed. I think with this I stop. Thank you.
Thank you very much, sir. Mr. Chandrasekharan, sir.
Thank you, sir. Mr. Ravindra has pointed out a very
Yeah,
good,
but we will not talk about a specific case here.
No.
Sorry,
I'm not going to talk about that particular case. Sir, I would not call it as a death. It's a mercy kill, probably verdict. And when you have given a mercy kill verdict, and instead of distributing the organs, if there is a possibility to revive that particular person, it should be. But only thing is that should be a time bound activity. It cannot be that after 2 years you come and do all these things.
And I think the condition is very clear that it's only in case of 33(1)(b), non-compliance or contravention of resolution plan.
Exactly.
It's not for non-approval of resolution plan.
Exactly. That is one. And the second one, sir, already under Companies Act, I think 360, there is a compromise agreement which can happen after declaration of death in this case, right?
Section 230 is what you're talking about. Section 230 you're talking about. But that's also been a failure, because I think there has rarely been any success of Section 230 in reality.
Exactly. So it's usually been given as an appeal, usually given an escape route, and that should be given always. Otherwise, it will not be there. It is not coming in a full round of law. Probably that could be the reason for this particular thing. I don't know how many cases will fall in this, but I'm sure that there should be escape route which should be provided after the mercy kill is been declared.
Right.
Yeah,
Mr. Shivaraman, sir. I can see Mr. Shivaraman's hand raised, but should there be nothing further to say, that maybe it. Mr. Shivaraman, do you want to? Yes, sir.
Yeah. First of all, with regard to the implementation of the project, it should be clearly defined in the law that the time bound should be in this manner only. Then only this can happen. Or otherwise, if it is not fixed up with regard to the implementation of the project, then this will be used as a tool by everybody in a different manner altogether. Because every RA will start using this as a tool to work out certain things.
That is true. It's not, it would probably be contravention of resolution plan or rejection of plan in terms of 33(1)(b). That's a very limited circumstance. So while the use of this so-called reinstatement is quite limited, nevertheless, the whole issue would be how does it lead to a timely extraction of value. The whole objective of the law is timely extraction of value. So I think we note the concerns. If you can maybe then thereafter move further. This is another very important provision, proposal, which says in case of interdependent assets, which is quite commonly the case. There are assets of a guarantor, for example, a promoter is a guarantor, a holding company is a guarantor, where the assets are dependent on the assets owned by group entities, say the promoter entity or say the promoters personally, such that resolving the corporate debtor without involving the assets of the guarantor would be tough. For example, the land on which the plant is standing is belonging to a guarantor, or the trademarks are with a holding entity. So in such cases, it should be possible to club together the assets of the guarantor as well, which in a way we are saying we are crossing the boundaries of the legal entity and piercing or lifting the corporate veil and including the assets of the guarantor as well as a part of the resolution estate, so to say, to incorporate those assets too. This is in principle of insolvency, there are only rare cases, rarest of rare cases, where assets of other entities may be included in the part of liquidation estate. There have been rulings in the past in some countries, but extremely rare cases. But here we're talking about a guarantor who has provided guarantees. Presumably, the guarantor might have created security interest on those assets. If the assets are secured in favor of the creditors of the entity in question, the CD in question, it might then be easier. But if the guarantor has not created security interest, the assets are free from security interests of the creditors, and there might be other creditors who have security interest on those assets, then this guarantor property consolidation, so to say, will be still a challenge. Globally, there are cases where this has been done, but last few years there have been rarely, even the US, where there's a company, a famous US ruling called Corning PLC. There this was tried, but subsequently the courts have restrained or refrained from ordering consolidation. So-called group insolvency is mostly a coordination, not consolidation, as we see in the next slide once again. But in the meantime, on this, if anyone has any feedback to offer.
I consider this as a very welcome move. I am not sure what litigations could go up to the Supreme Court regarding this amendment, but it is a welcome move. As Vinodji rightly told, there are many cases where the lands are in the name of the promoter directors and the buildings are in the name of the company. And I have seen cases where the promoter directors have taken a view that number one, it is difficult to sell even in liquidation, and that is the promoter directors use that as a arm twisting tactics to defeat the objective of the creditors. That is a welcome move, but we may have to keep the fingers crossed as far as the related litigations are concerned. Thank you.
Thanks. And likewise, the next proposal, which is group insolvency, there is a separate discussion paper altogether on group insolvency. Discussions about group insolvency have been going for quite some time. There are some cases where group insolvency has been tried in this country. Videocon, of course, is one of the very well-known cases. Here we're talking about coordination. That would mean in case of group companies. Group companies meaning holding, subsidiary, and associate companies. If there are multiple companies which are into insolvency, in that case, the insolvency of these related parties shall go on a coordinated manner. When we talk about coordination, we are saying there might be a common adjudicating authority and there might be a common resolution. Professional COCs, of course, will be, because there'll be entity-based COCs anyway, but the COCs may also provide for mutual coordination. So I think in principle, I don't think there would probably be much of a debate on this, that if at all insolvency of related entities can work as a group of related entities, it could probably achieve better results. But otherwise, quite often, the estate of the corporate debtor is so spread across multiple entities, and it is such a complicated way, some of which actually might be in other countries as well. And therefore, this has to actually be combined with the discussion on cross-border insolvency as well, that it's impossible to think of sale of some of the assets without bringing other assets. So the group insolvency concept has been discussed, I think, for a long time, almost like 3-4 years now. And we are adopting the global approach, which is coordination rather than consolidation. Consolidation would have meant we disregard the legal entities and bring the entire assets of the group into one single fold, but that would dent the principle of separation of legal entities. So we are restrained or refrained from doing that, and we're talking about merely a group-wise coordination. Mr. Ashwini Mehra.
Yeah, no, on the last part that you said, am I audible? Yeah. On the last part that you said, actually, very often the one single promoter or a couple of the family members, they hold different legal entities, doing the same activity, around the same activity. And unfortunately, the insolvency law applies only to companies, and they actually take the benefit of that by preparing for the insolvency by transferring some of these assets into other legal entities which cannot be brought into the corporate entity in the group, which is something also that this law will have to take care of, though I mean the avoidance etc. Do provide for the transactions, but establishing those avoidance transactions etc. is also a very Herculean task at times because of the different legal entities which are involved. So I think the thought on consolidation also needs to continue to be kept in mind, where we actually see that a different legal structure is being used in various parts of the group only to defeat the creditors from getting their dues from the group.
Yeah, I think the point is well made, sir. The point is well made. And Mr. Mahesh Mittal, would you like to add?
My point is, in case a group has say 5 entities and 2 entities are performing well, and there are some default issues in the remaining 3 entities, then we can only go for the resolution of 3 entities, not the entire group. So in that case, the group insolvency may not apply. And secondly, of course, the point already made that some entities may not be covered in the IBC because they are not corporates or not covered under the CIRP, and as such they may escape the insolvency route.
I think you are right that if the assets are partly in non-corporate entities, such as individuals, then we'll find it difficult to extend the law. But mostly, I would say, while you are right that there might be some cases of individuals and non-corporate bodies as well, but mostly the assets are across subsidiary companies, associate companies, overseas entities, etc. So when we talk about consolidation, it has to come with a full package. The package has to include cross-border entities as well, because very often the enterprise is intertwined with entities across the country too. So this might therefore make sense only when it is clubbed along with cross-border provisions. But with relevant detailing here also would be necessary. But relevant detailing, perhaps this might be a welcome. I mean, it might actually be needing further expansion, not just group entities and subsidiaries and the associates, but even the wider definition. For example, Securities Contracts Regulation Act, the ICDR regulation talk about promoter and promoter group, a much wider concept. So it perhaps might be even sensible to think of expanding the definition. Mr. Shivaraman, sir?
No, my other point, Mr. Kothari, was that in case you have 5 entities and 2 are profit making and have no issue of default, so how you can, do the CIRP for all the 5?
There's no question of getting an entity which is not insolvent into the fold of insolvency. The entity in question has to be insolvent. Yeah. So if there are multiple entities which are into the holding entity is insolvent, the subsidy has been called into insolvency, group entities also into insolvency, the whole idea might work only if the entities within the group are into insolvency. We cannot regard the insolvency merely by using this provision. That would mean there has to be a default.
And sorry, just one correction. I'm sorry to interrupt.
We have seen
one correction. In Lavasa matter, all the entities that were into group insolvency were not under CR. Just for your information.
Maybe I'm not aware of the particular facts though, but
no, I was a part of COC. I know that. That's why I'm just telling.
Okay, all right. Because the idea basically is that either they're guarantors, in which case you need to invoke the guarantee, or there is a debt which is owing to the creditors of that entity as well, so that you can trigger the insolvency. Because a solvent entity cannot be brought into insolvency merely because my parent or subsidiary company is also into insolvency. That's not a ground to breach the so-called corporate veil, lift the corporate veil and bring the assets of a solvent entity to supplement the assets of an insolvent one. Because that is done, then the whole concept of limited liability will become irrelevant. However, Mr. Shivaraman, sir?
Sir, is there not a concept called as consolidated balance sheet being prepared for group entities?
Only for
as
reporting
well as
purposes, not for insolvency.
That does. No, I'm coming to that point only. When a company is coming under, when you are supposed to report on a consolidated balance sheet, based on the consolidated balance sheet, and if the companies are under insolvency, why cannot they have a common COC and other things to happen? This can happen, right? So that things can make it very clear. This is one point which I want to say. When you are asking for a consolidated balance sheet in the Companies Act, and if the group is under insolvency, that can be taken as a forward mechanism to complete the insolvency process. That is what is my point.
Mr. Varun Sethi. Varunji, if you're not audible, perhaps.
Am I better audible now?
Yes, you now.
Thank you. My question is, in the previous slide, what happened was the corporate guarantor or the personal guarantor. It mentions that the COC can initiate with the insolvency of the CIRP process of the CD, as well as for the personal guarantor if they are the corporates from a group insolvency perspective. Now, and in most of the cases till now, say end of 2022, the CIRPs have been initiated, but probably corporate PG has not been initiated, or personal PG might not have been initiated. So what will happen is a question of the limitation law will also enter here, if at all. So that's exactly the clarification that I'm expecting. So say, for example, a CIRP admitted in 2018 or 19 for that reason, a limitation law from the perspective of the dues recoverable from a personal guarantor, are they subject to 3-year limitation? Because the CIRP was initiated in, say, 3, 4, 5 years back.
I know that limitation question will remain significant, even though there are several Supreme Court rulings on what exactly is the meaning of limitation. And but I think you're right. The point that you made is very valid, and we expect that whenever the law is made, it probably addresses that question as well. Given the time,
so can't we restrict the understanding to the fact that because the claims were admitted in, during the process of CIRP, and say, for example, the CIRP is currently ongoing, or liquidation is currently ongoing for the CD, the liabilities of the PG, be that individual or be that corporate, are coextensive? Is it not that simple, or is it like more complex than this?
I think nothing is simple when it comes to liabilities and limitation. I'm sure you would have seen there have been multiple rulings of courts on a law which is a 19th century law. The law has been there for almost like 100 years, I mean, or let's say some 7-8 decades, with enormous amount of jurisprudence already. Still, when IBC came, we started writing a new limitation law. So limitation law itself is quite a contentious topic, and we hope that litigation wouldn't erupt once again on this, and therefore if Shushanji is listening to this, probably might take care of that while drafting the rules or drafting the law when it comes to the limitation point, which shouldn't be stuck on the ground of limitation merely because we did not initiate the insolvency of the related entities.
Agree. Yeah.
In the interest of time, if you allow me to maybe move a little fast, because we got barely some time left and a lot of slides still, a lot of provisions still to be discussed. Section 53, the waterfall, and that's a very significant provision because we're now thinking of collapsing the waterfall to merely 4 categories. I'm not meaning the preference shareholders and equity holders, which anyway would get nothing during insolvency. Currently, we have 6 layers, leaving the first and second anyway untouched, because first, second, third. That is insolvency resolution, process cost and liquidation cost, if any. Workmen's dues and dues to secured creditors on a pari passu basis as usual. Employees' dues comes at 3rd level. And right now, the 4th level talks about unsecured financial creditors. And the 5th level thinks of 2 entities, the government dues and the post-relinquishment dues of the secured creditors. And the 6th level comes operational and other creditors. Now, these last 3, 4, 5, and 6 are proposed to be collapsed into one single category, such that we have only 4 categories. Cost number 1, then comes workmen dues and creditors, secured creditors, then employees dues, and thereafter all other remaining claims. It's I would say, such a significant rethinking of the law, because waterfall is the essence of insolvency, and we are trying to. I think I don't have any objection though, because there's no reason to put unsecured financial creditors and unsecured operational creditors on a different platform. In fact, that is something that we had contested long time back when the law itself was being done, that contractually unsecured is unsecured. Secured is one class, unsecured is another class. Unsecured creditors, once again, distinguishing between those who gave money and those who supplied goods and services. There's no reason, there's no basis for that distinction. These points were argued in 2016 initial Supreme Court ruling, innovative, etc. Also, these points were raised, but eventually we're coming to this recognition that we don't need to distinguish between unsecured FCs and unsecured OCs. Any thoughts? The proposal is very significant, but any thoughts? Kindly say.
Is that the first point to be addressed is that with regard to the second point, secured creditors, again and again we are making a mistake. It should say secured financial creditors. If we don't say this, there is a point of lot of litigations coming up.
Sir, why did you think it should be secured financial creditors only and not secured operational? Normally, operational creditors are not secured, though. Normally, they're not secured. But there are cases where.
That is where the point of contention happened in the case of Rainbow.
If you're referring to government dues, then there is a separate provision to which we're just coming to. That is separately getting addressed.
But one thing is, again and again, if you say secured creditors, what do you mean by secured creditors? The meaning of secured creditors is nowhere written in the book. The explanation, the meaning, the definition of secured creditors, what does it mean? Is it anywhere in the IBC law? No, it's not there. It says about financial creditors. It says about operational creditors. These are the two classifications which you have done. Only in the case of liquidation, you come across this word terminology called secured creditors and unsecured creditors.
Right. So, my thinking on this is that, and if one reads to the BLRC report, it becomes clear that the distinction, so let's first understand that when it comes to insolvency law, we distinguish between secured and unsecured. We don't distinguish between financial versus operational. World over, there's nothing called financial versus operational creditors in insolvency laws of any jurisdiction I can think of. BLRC in India made the distinction between financial versus operational from point of view of who has the right to sit in the COC. Idea was that COC should consist of financial creditors who are informed entities. They are bankers who are given credit. So they are the ones whose big stakes are involved. They are people who can actually do a meaningful contribution to a resolution plan. So they should be sitting in the COC. So the idea basically was we distinguish between these two for the purpose of COC constitution, not for the purpose of distinction in waterfall. To say that an operational creditor and financial creditor, the one who is both are unsecured, should still have a disparity and not a parity is actually, I mean, hitting at the very contractual right. Every unsecured creditor is equal in law, because if you don't have an interest on an asset, your rights are exactly the same. So that waterfall, first of all, distinguishing between unsecured financial creditor and unsecured operational creditor. If I'm sort of still, I mean, referring to my own write-ups, but way back in 2016, when we wrote the treatise on the law, we said this is actually defeating, because this is going against contractual principle. Anyways, the intent now is that we are distinguishing based on security interest, and then of course we're giving equal parity to workman claims, as always has been the rule in this country, and next come the employees, and finally all of the creditors. So that's the proposal. Mr. Shivaraman sir, you made your point. Anybody else who would like to
Sir, my simple point is, why don't you define a secured creditor in IBC?
Would help, sir. If the definition is there, that would definitely help. But the point that you made about government claims, which came from Rainbow Papers, that is anyway getting addressed. In fact, I think Rainbow Papers, with extreme due respect, maybe the court was not apprised of the provisions of SARFAESI Act, because SARFAESI Act is also very important. And SARFAESI Act 26 BC-D each say clearly that unless there is an attachment which is registered with SARFAESI, it will not take the status of a secured creditor. The government may become a secured creditor if the government has done attachment of the asset and has registered the attachment with SARFAESI. Otherwise, the government is not a secured. That law probably was not brought to the notice of Supreme Court, hence this ruling. But maybe now they're trying to tackle this by explicit provision overriding the impact of the Rainbow Papers ruling.
Just to add here, secured creditor has been defined under section 330 of IBC, and it clearly says as any creditor. So it doesn't matter whether he's financial or operational, just that the conditions precedent under the definition should be satisfied.
Which
and
is
that's what distinguishes a transactional secured creditor from the tax creditors. Because in case of secured creditors, we create the security interest. In case of tax creditors, it is statutorily there. So that's where the distinction is coming in.
Maheshji?
Yeah, just I wanted to say the same thing, that section 3, subsection 30 of the IBC defines secured creditors, a creditor in whose favor some security interest has been created. So it will include both the financial creditor as well as the operational creditor. There is no distinction between the financial and operational creditor to the extent it is a secured creditor. It can be anybody.
Right.
Yeah.
Next proposal basically is that valuation estimates will form part of the information memorandum as well. This has been there in regulations for quite a long time. So this is nothing new as far as regulations are concerned. Now probably it's supposed to be included in the statute itself. I don't think one can probably have much of a concern on that. So if you think we can maybe move on to the very important point, which is anti-deprivation principle, also called ipso facto clauses in contracts. Just to give a quick background, and this is also coming from Supreme Court ruling in Gujarat Urja Vikas Nigam, which is dealing with centuries-old provision of insolvency laws that if there is a contractual provision which says because the contracting party is insolvent, that allows the other party to trigger an event of default and therefore terminate a contract. I'm sure you would see it in every contract. When you read the events of default clause, the standard event of default clause says if the other party becomes insolvent, I have a right to terminate the contract. So this is, now in case the insolvency itself leads to termination of the contract, then contractual rights would lose their value. For example, if the value of the corporate debtor lies in, let's say, a concession agreement, or let's say leasehold right, or let's say licensing right, or say a PPA right, then the rights will become frustrated if the insolvency itself is used as the condition for terminating the contract. So in Gujarat Urja Vikas Nigam, Supreme Court said if the breach of if the contract termination is like pulling the rug under the legs of the corporate debtor, then we will not allow it to happen. But the Supreme Court said, while I'm doing it exceptionally in this case, however, this is something which is to be tackled by the statute. And that was the ruling. And I think now the government is responding to that and proposing a change. However, the change is only in respect of contracts with central government, state government, local authorities, and statutory bodies. Globally, the so-called anti-deprivation principle works in every case. That would mean irrespective of who the contracting party is, insolvency cannot be used as the event of default unless there is a default under the contract. If the contract is being successfully performed, merely the event of insolvency cannot be used to deprive an insolvent of his contractual rights. That's a global position. But in India, we're trying to bring it only to a limited scope, with contracting parties being corporate, central government, state government, local authorities, statutory dues. Another point which I'm sure Sushant Dasji would like to note is that here we're saying these bodies being operational creditors, actually they may not be creditors at all. Nothing is, for example, due to central government, state government, local authority, or statutory bodies. The idea basically is that the contracting party cannot use insolvency as the ground to terminate a contract. If we refer to these bodies as operational creditors, then we are necessarily presupposing that there is something due to them, which may not be the case. So that's what the law is proposing to do as far as anti-deprivation provisions are concerned. Does anybody have any thoughts to express on that? Or else, if you allow me to maybe proceed further. This is, Maheshji, you wanted to say something?
Sorry, I just wanted to say, like that contractual agreement, say for supply of power to the factory, there is always a clause that if there are dues outstanding for 2 months, 3 months, they have a right to disconnect. So it is not out of insolvency, but suppose at the date of insolvency commencement, there is outstanding dues, whether then they can disconnect the power.
So essential supplies, I think even currently we have protection, essential supplies only, but I think this is an important point that you have made, and I'm requesting Sushantji to also take a note of it, that it's not merely to a person to whom dues are pending. The idea of anti-deprivation or so-called ipso facto clauses is that if insolvency of the entity has been used as the pretext, as the reason for termination of a contract, then that would kill contractual rights. Because many entities currently have contractual rights only. For example, concession rights. Take the case of a PPA. The entity is a supplier under a PPA. Now, if I say that PPA stands terminated because the entity went into insolvency, then the very value of PPA goes away. So it's not because of contractual default. It should actually extend to all situations of so-called ipso facto termination of a contract and protect the insolvent entity from facing termination on account of insolvency as an event of default. That is actually the idea. If we were to maybe make a move from here, protection against civil liabilities.
One point.
Yes.
One point on the earlier observation. Here the disconnection of the electricity connection is a temporary feature. There is no termination or suspension of the agreement. The agreement or your connection agreement that will remain in force. That is one part of it. And the secondly, this is a matter of court ruling that the essential supplies cannot be disconnected. So once CIRP has commenced, that benefit will be available, and electricity company will not be able to disconnect the power supply if we submit the copy of the CIRP order.
So essential supply is a very limited scope, but here we're talking about any contractual right, not just essential supplies. So I think the scope is considerably wider when it comes to so-called ipso facto clauses. The next para talks about protection against civil liabilities. I think this is to an extent already incorporated in section 32A. Probably the scope is getting, proposed to be made clearer and maybe wider to ensure that the resolution applicant does not face lingering or sort of backlash or sort of hangover of the offenses, legacy, so-called legacies on account of civil defaults of the erstwhile entity. That is what is proposed. I'm wondering if anybody has any thoughts on that. But the next point, which is extremely important, and I would like to hear from you all also, because all of you have been in practice and have been running COCs in the past. This point actually seeks to say that while computing voting at the COCs, we will not be looking at the total voting strength. We'll be doing two things. Number one, from the denominator, we'll be excluding the voting share of the related financial creditors. So we'll not count the total votes as total votes only. We'll exclude from denominator itself, we'll exclude the votes of related financial creditors. And that apart, will count only the votes of those who are voting. That is, we will not count the votes of those who are abstaining from voting. So when you talk about 2/3 majority, we'll talk about 2/3 who actually voted and not the 2/3 including those who did not vote at all. Now, this is what I will say the essential law of meetings is that those who are called upon to vote, who have a right to vote, do not come to vote at all. We cannot include votes of those who did not exercise the voting rights at all. And this is so-called basic settled law of meetings, be it corporate democracy or be it public democracy. We always talk about those who exercise their votes. Now, this proposal, though, comes with a rider, and the rider will therefore make this, the move will be, the effect of this will be curtailed because of the rider. The rider, however, says that the votes of those who voted, that is those approving the resolution plan, should at least be 51% of the total voting strength of COC. Of course, there also will exclude the related financial creditors, but it should at least be 51%. To cite an example, suppose the total voting strength is 100 and 20 do not come to vote at all. So we are left with only 80 who are voting. And then we're counting 2/3 of that. So 2/3 of 80, which is whatever, 53 point something. So that is still satisfying the threshold condition, which is 51% of the total strength of the COC, which, as we discussed, was, let's say, 100. However, say it's talking about more than 51. So let's say if 25 abstain. So out of 100, say 25 abstain from voting at all, and 75 is those who vote, and we compute 2/3 of that, that merely comes to 50. So that is still not adequate. So by this, what you're trying to say is that if 25% or more in value of the financial creditors who are entitled to vote do not vote at all, they can deadlock the voting process. By not voting, so my submission, I mean, with whatever very limited experience I've had, and I think you all have much richer experience, is that the biggest problem in current working of COCs is that those who come to COC meetings, they don't decide. They mostly in the COC meeting say, oh, I'll have to go to my head office, I'll consult my seniors and then decide based on that. And that process going to HO, consulting seniors, that can take its own sweet time. So quite often, the COC members don't vote at all. Or they do a sort of qualified vote, subject to so-and-so. So in a sense, if somebody was not voted at all, can he sort of stall or hijack the voting process by not voting? There, if you think, if the voting strength of those who are not voted is 25% or more, they will still stall the decision making. So that's, to my mind, that would greatly limit the impact of what MCA or IBB is proposing to do. However, let's hear from others as to what you have to say on this. Anyone has any thoughts on this? Is this something that you would recommend?
I do.
Sir. Yes, sir.
I do have. For an example, this two-third whosoever is voting would be counted. It's already in some part in real estate projects where financial creditor in a class always been the voting process happens basis the number of votes which is got casted versus what is voted for, right? It's not the whole this thing. So already it's there in some part and pieces there in the current IBC process. So hence this is an extension. So I don't think that is a very bad thing. But you are right, sir. The people who are all not voting, primarily the financial creditor who has to take the consent from their supervisors. And actually, we have to do a little bit differently here, sir. In my view, we have to have an punishment mechanism. If at all you are not voting, and it would be treated that you would it is for the voting type, right? Something has to happen. Otherwise, the financial creditors are not coming on board for voting at all. It's a very painful activity, and somewhere we have to draw this line, and we have to tell them that, see, everywhere there is a timeline, right? Why on voting process there is no timeline? There is no liability on them that if at all they are not voting. Somewhere we need to draw the line there. That's what my submission, sir.
The part that you just mentioned, very interesting part, that those who are not voting, there should be some kind of punishment mechanism. That would mean if somebody is not voted, let's say on 2 occasions, then 3rd occasion you are not allowed to vote. And something to sort of either admonish or maybe publish the name of the bank which is not voted on more than 1 occasion, etc. IBBI may think of, pooling a database of those who are not voted or not voted in time, because I do understand that IBBI is coming with a code of conduct for COC members, which is currently looking like a motherhood statement. It's like principles of being good boy. That may be concretized to make it more, I would say, tangible, resulting into some bit of penal implication. Penalty doesn't mean money. Penalty can mean penalty in many ways. Even reputational loss is a penalty. So there might be ways to not just mobilize creditors to vote, but also penalize those who are not voting and probably not voting in time. Mr. Devarajan, sir?
The president voting, as we understand in other places in Companies Act, is slightly different here. Because here what happens is that when there is a COC that is happening, somebody may be present, right? Somebody may not be present. Now, when the voting happens through the voting portal, the person who is not present in the meeting may also vote. So are we saying present voting will be those who voted only? Because see, look at the liquidation regulation, 31A9, subsection 9. It was present and voting. They have removed present in the amendment on 16 September and said only voting. So when we are talking about present and voting, is it that the COC, when suppose a member attends the COC meeting, then only is permitted to vote? Or he can be absent in the COC meeting, but yet vote? There is a practical difficulty.
Understand,
Especially
sir.
look at the context of the liquidation regulation changes in 31A subsection 9. The
Yeah,
present and voting, they removed present. So there in liquidation, SCC, if you don't attend also, you can vote.
Since the voting happens by e-voting process,
yes, so that clarification is required here.
By presumption, anyone who's voting is present in voting. How can you vote without being present?
I'm just telling you in the context of the changes that happened in the liquidation regulation.
So the word present as such is not actually important, because what is relevant is only voting.
Only voting.
And I'm hoping that Mr. Shandas can maybe take a note of this.
Possibly you can, suggest that particular point.
Sure.
Thanks.
Absolutely right. Let's maybe move to the next point. Okay. Let's move to the next point. We are talking further about interim finance and sort of encouraging interim finance. I mentioned that there's hardly an interim finance in the country. There's hardly any activity in terms of DIP financing or interim financing. So now a small sort of motivational proposal which says that you can now be a part of the non-voting members of the COC as sort of as spectator or observers in COC. So you are not completely away from the process. You are participating, though you don't have voting rights, but you can still be on the COC. I am hoping that this, one wonders whether this would be sufficient to encourage lenders to lend interim finance. I think the bigger issue is the prospect of realization, because most lenders currently know that if the entity gets into liquidation, how long will liquidation take and what will be the value realization, something that they don't know. Though interest and principal payable to an interim financier is part of clause A, the first priority itself. However, when will liquidation happen? How much will be the realization out of liquidation? That is still buried in doubt, and that's why interim financiers are not very keen to extend interim funding, particularly for entities which hardly have got any value, which is where the interim finance is most needed. So it's been a non-starter, but I'm wondering whether this could actually encourage lenders to extend interim finance. If somebody any thoughts, kindly say, or else we will continue to move to the next provision.
Probably we can divide this interim finance into two parts, sir. One is that for running a going concern where you require money, somebody has to fund, right? Another one is to carry on the CARP process where the bank account is not operational at all time, right? And probably if at all this can be divided into two parts, and definitely if it is a going concern, to run that going concern, the funding whosoever is making, they will get the return, and probably the risk premium can be attached in the interest portion, right? And for running the CARP, definitely the COC has to mandatorily contribute. Now they are not contributing mandatorily, and they are also leaving to the last, right? So that can be a game changer if at all we can split this into two.
The interim finance that we're probably talking about here is external financiers lending during resolution, not the committee members extending or contributing to liquidation costs, perhaps. So is there a motivation? The question basically, is there a motivation given the risk and the indefinite time taken in the present proceedings for completion of liquidation? Is there a motivation for lenders, external lenders, to come forward and lend to a company which is already into insolvency, even though it's super priority when it comes to priorities? But so far it's not picked up. I'm not sure whether making them as members of COC will actually help to encourage interim finance. The next provision is in case of entities involving public interest, the government may appoint an administrator instead of an insolvency professional occupying the position of IP. The government may place administrator, same as in case of financial entities currently. Administrators are appointed by RBI. Similarly, a power is sought to be conferred on the central government, or such authority as central government may notify. More likely maybe the IBC, perhaps, I don't know. But in public interest, is, well, once again, a matter of broad interpretation. There, the government may get the right to nominate the insolvency professional. So one wonders in what all cases, other than financial companies, will the government be doing it? If it's done, how does it preserve or protect public interest? And are we therefore saying that the IP wouldn't have so much cared for public interest as the administrator? I'm wondering what is the thought process, but that's the proposal which is there by the MCA. Any thoughts around this?
Not so great provision, sir, as an IP. And apart from that, this is diluting, right? And say, for an example, during a COVID period, and the government may say that all the probably pharma companies are the companies with public interest, right? And suddenly, lot many things can happen. But that's what I'm saying. There can be a supervisory body, maybe a special technical member who can supervise those public interest companies, CARP. But having separate administrator would not yield what has to be done. The purpose is getting defeated here.
Because we created an ecosystem of insolvency professionals. Now we're suddenly saying this ecosystem doesn't work. I'll get another entity here, which is the so-called administrator. So in a way, it's indicating a little lack of confidence on the IP profession.
It's in the same continuation theory of IPs getting a license for IP, right? So it's more of an non-confidence on IPs, individual IPs especially.
That too after 6 years of being IPs. Okay. Maheshji, would you like to say something? Mr. Devarajan, sir, you also want to say something? Yes, Maheshji.
Yeah, I just wanted to say, like, we can propose, like, instead of putting non-confidence on IPs, like SEBI is appointing IPs as administrator. So government can consider IPs also to be appointed as administrator.
And all you're saying is that instead of this creditors appointing the IP, it should be appointed by the government, or maybe appointed by the government.
Yeah, if government thinks so, in some public interest matters, they want to appoint directly. So they may consider IPs also to be appointed as administrator.
In other words, move the control of who the IP will be from the creditors to the government, but keep the IP as insolvency professionals still.
Right.
I mean, worth considering.
Like SEBI is doing that. SEBI is appointing IPs as administrator.
Very true. The government also wants to keep a power of exempting certain entities. What will those entities which are exempted from IBC provisions will be? Either certain entities or class of entities. For example, MSMEs, they might probably have a separate MSME insolvency regime separately, or some other class, they might probably have some different process or provisions. So like there's a power of exempting in the Companies Act to private companies or Section 8 companies. The government wants to keep similar power in IBC too. Given the time that we currently are at, so if you maybe permit me to skip the personal insolvency part, which is not really great, simply aligning personal guarantors with the same principles as corporate defaults. I'll move to the parts which are dealing with liquidation. Some of these are very important recommendations. One part is direct dissolution. Some NCLTs have already passed orders that if we find that there is nothing in the entity left, therefore there's no point in moving from resolution to liquidation, we can jump directly to dissolution. So that is now legally sought to be coded, that if resolution fails and the creditors come to realization that there's nothing to liquidate, it's simply moving to dissolution will be fine. So a statutory power is sought to be incorporated whereby the entity may directly move to liquidation. That was already done in some cases, like NCLT in Bengaluru, NCLT Chennai have done it. Also, there is a proposal to eliminate duplication, for example, elimination of claims or admission of claims. That's done during resolution. The same thing is repeated in liquidation as well. Currently, there are enabling provisions for not inviting claims or not doing valuations by way of regulations. Now, the enactment also wants to have the same flexibility to save the repeat of procedures, for example, invitation of claims, etc., during liquidation. Though I'm sure all of you will come back and say that the claims during liquidation are as on the liquidation commencement date. The claims during CRP are claims as on the commencement of insolvency. And between insolvency and liquidation, A, the claim values might have changed, B, the claimants might have changed. Therefore, how can one actually avoid filing of claims at the start of liquidation process? But to the extent the procedures may be eliminated, they might be overlapping and might be eliminated, it might help to reduce the procedural time lost. If you all permit me, given that we are already 20 minutes past the scheduled time, maybe I'll move to some very significant provisions pertaining to liquidation. This one, for example, is extremely significant. It says there will be mandatory COC during liquidation. Currently, the little experience we had with stakeholders consultation committee. Now, stakeholders consultation committees are good when it comes to advising the liquidator. The right is still given to the liquidator to run the liquidation process. Liquidator may do consultation with stakeholders, which is where the liquidator does consultation with the stakeholders consultation committee. But in law, the decisions are taken by the liquidator. Now, the proposals are that since ultimately the liquidator is fiduciary for the creditors, it's they who are the beneficiaries, and therefore the creditors are the ones who should have the right to take commercial decisions. Now, there are both the sides of the argument. This is seemingly like a pristine argument that after all, the liquidator is working for the interests of creditors, and therefore, how can he not listen to the creditors? Part one. Part two is that eventually the CRP process was creditor driven. It was dictated by the creditors. And the CRP came with a challenge in terms of timelines that if you don't decide within X number of days, then your right to decide will be taken away and the entity will be handed over to a professional who is the liquidator. So once the entity moves to liquidation, the liquidator works under direct instructions of the adjudicating body. He is not as such dictated by the decisions of the COC. Now, if you see internationally as well, this position, UK, Singapore, US, as a part of the BLRC reports also, it says creditors have no direct, I'm reading from BLRC report, which is at the bottom of the screen, no direct intervention or no direct interface in the working of the liquidator. In Singapore, UK, US, everywhere, when it comes to liquidation, it's the liquidator who works under instructions of the court and not based on the decisions of the creditors committee. But the law is now proposed to be changed to make the liquidation also subject to commercial decisions of the creditors. Here, the biggest problem would be that creditors are creditors of different classes. There are category A, let's say the secured creditors, then come the employees, along with category A are the workmen as well. Then there are, let's say, remaining claimants as per the revised waterfall. Now, each of these creditors belong to different classes and therefore their stakes in liquidation are different. Operational creditors, for example, know that they're going to get nothing because mostly the waterfall is completely dried by the time we reach to that level. So their interests are not similar. The interests are mutually conflicting. One can think of a collective decision-making process when the interests of each of the stakeholders are similar. Then you can probably think of let's hear from everyone. But hearing from everyone where their interests are completely diverse and therefore mutually conflicting, whether that process actually works or not is a question. Now, I would say my experience with this is extremely limited, but I would like to hear from you as to how is liquidation working under the aegis of the SCC, and if the SCC becomes a statutory creditors committee as proposed, how does it work? Mr. Chandrasekharan sir, Mr. Shivaraman sir.
Sir, the basic difference between a COC and an SCC is that SCC comprises of all creditors, whereas COC comprises mainly of financial creditors who have the voting power. This is a major difference which is going to happen. Suppose, for example, if there is a claim of 100 crores from a financial creditor and there is a tax liability of 300 crores from a tax authorities, who is having the voting power more in the case of liquidation? And none of your resolutions will get passed for the simple reason being he is not going to get anything. Are we going for a deadlock?
that was my point, that it's indecision which leads into liquidation, and making liquidation also as creditors process will extend the indecision. Indecision leading to further indecision. Therefore, where are we? If we have indecision in liquidation also, then what next? Because liquidation is the terminal process, nothing further. There's nothing beyond that. And therefore, if we have indecision there as well, what do we achieve? That was my perspective too.
And second thing is with regard to asset sale and realization. For example, when we are going to distribute it, we distribute it according to the money value which has been given and according to the sharing ratios. Now, necessarily when you come to sharing ratios, you have to get the approval of the SEC. At that time also, you will have a problem when you will not be able to pass the resolution, get it voted. Again, stumbling blocks everywhere.
No, I would extend the point a little further to say that quite often there is a litigation. Let's say the workmen are agitating on a certain matter. And of course, as the liquidator, you need to defend it. Therefore, you need to appoint a professional to defend it. That will also be objected to, because there are mutually conflicting claims here. So how do you expect the workmen to support the appointment of a professional who will be standing in the court against their claim? So that's where the, multiplicity of claimants with completely diverse claims, and they are sitting in a common forum to decide. So this is probably a little over-optimistic thought process, but I would also want to hear from Mr. Chandrasekharan sir, if you have any thoughts.
Yes, sir. I also go with your this thing only. Vinodji, you rightly pointed out. Already we have tried with the financial creditors who were in the driver's seat and could not provide any way forward. Hence, we are into this liquidation stage, right? And the stakeholder committee, of course, it is already there, but there is no need for us to follow. And if there is a deviation, we can file a deviation report why we are not following their direction, right? SEC. If it is actually going to put a disturbance in the process of liquidation. And again, this is also going back to the same story of not trusting the IP or IPE. Probably the IPs should have free hand to do this. Anyway, auctioning we will do, right? And these are all well monitored auctioning. And why do we require a lot many people to decide along with us and to decide the auction winner, right? And how to distribute, already it's been defined. So probably it's a overkill in my view.
In reality, sir, it's the JLF which fails first. Indecision kills the joint lenders. If JLF worked, we would not need IBC. So JLF fails because of indecision, we then get into IBC. IBC fails because of indecision, we enter in liquidation. If liquidation, we still have the same prolonging indecision, I'm not sure where do we then ultimately end up. Mr. Ashwini Mehra?
Actually, the law already provides for an oversight from the SEC members, and they can, if their interests are harmed, they can always go to the NCLT and ask for a change in case they find that the liquidator is working against the interest of the stakeholders or even of the company under liquidation. By making these changes, actually, as rightly put by all of you, the process of decision making will get even further slowed down without much value addition. In fact, it will prolong the process, and we will have a situation similar to what we have been facing even in the CIRP. Again, there will be a lot of indecision, or we'll not have conclusive voting on various things, and we will be stuck up in the liquidation process, whereas liquidation is something which the anticipation is should get done quickly, followed up with a winding up. However, that doesn't seem to be, the changes seem to take it further away from that.
Right, sir.
Thank you.
Replacement of liquidator is already provided by the regulations currently, 16 September 2022. Now this is supposed to be codified in the law itself, that creditors may, with a certain supermajority vote, replace the liquidator. And there are, I think, the creditors so want that they are not happy with the liquidator, it should probably be okay to think of replacing. There's another very important change. This one is extremely important, and I'm sure all of you would appreciate that this is much needed, which is that once the entity is into liquidation, litigation against the entity in different other forums, labor court, provident funds, income tax, of course is a different story because that's assessment proceeding, but litigation, for example, civil disputes, arbitration matters, all of that will get consolidated in the NCLT itself. This principle was there in Companies Act 1956, Section 446. Equivalent provisions were there in the 2013 Act as well. When it came to IBC, the provision was sort of very mildly there. 33/5, for example, says prohibit continuation of a suit. But it did not talk about shifting of all the suits to adjudicating body. And now probably we are getting to realize that Section 446 equivalent is needed in IBC to say that there will be a stay on other proceedings during the liquidation process. And once the entity gets, if at all the liquidation succeeds, even a dissolution can be made without waiting for settling all the civil disputes. So the biggest issue is, if at all dissolution happens, liquidator's job is done, he goes home. I'm wondering who will be there to continue the litigation. But ideally, the way it should have been, that litigation, for example, provident fund dues, or let's say labor dues. Now, workers are still free to litigate in, let's say, different labor courts. Those disputes should actually come to company court, because the adjudicating body, because that's where a consolidated decision can be done for all the claims on the entity. If the claim is of civil nature, if the claim is of a criminal nature, well, let it be fought in criminal forum. Criminal suits are basically against persons and not against the entity. But civil claims should all be consolidated so as to be brought before the same adjudicating body to say that the suits will get stayed and will not get resolved. And that is not resolving the problem. And therefore, the proposed provision that dissolution will be allowed to proceed even while the civil claims are still pending, that actually makes the civil claims completely redundant. So maybe this is something that might require a little relook, but let's hear from others as to what you have to say. Mr. Chandrasekharan, Mr. Shivaraman, did you want to contribute?
Sir, I welcome this move, but with two problems in hand. One is that the NCLT is already overwhelmed and they are having huge pile up now, right? And I don't know how they will handle further number of IAs and the cases like this, which is getting transferred. And second one is that the specialized court like labor court and others, they've got a well managed system and knowledge to manage those specialized cases, right? And how do we expect that that specialization comes from here? So these are all the two problems which will enumerate. But however, it's a welcome move. Otherwise, we are all running between courts now before getting the stay, right? So it's a welcome move, but however, it's very tough to implement. That's what I could understand.
Right, sir. Anyone else who has anything to say on that? Well, I'm aware that we are already 30 minutes past the schedule, Maheshji.
Yeah, the point is, if court is fine, but if some matter is pending under arbitration, and arbitration is strictly not a court, so whether the matter before the arbitrator will get shifted to the court, to the NCLT, is it possible? I mean to say, how we deal with that? Because the contract may provide for settlement of certain disputes through arbitration. So that contract clause may not be overridden through this, unless it is specifically mentioned that even the arbitration cases will come here. So even some litigations may still remain outside this. And secondly, as mentioned earlier, like NCLT is not a specialized body for dealing different type of commercial matters, which are to be decided by either the courts or by labor courts or maybe tax authorities, tax courts, maybe appellate tribunals, and so on and so forth. So that thing may have to be kept in view.
Surely. Very well made point, Maheshji. I think we're coming to the last of the relevant points, and I will not spend much time on the service provider. That's not a greatly important point for all of us. In case of secured financing by multiple creditors, number one, relinquishment of security interest will be presumed, and this was already there in the IBC regulations for I think almost like 3 years now, but now it's being made a part of the statute that if relinquishment of security interest is not done within 90 days, within 90 days the creditor does not decide to opt for section 52, then he will be deemed to have relinquished the security interest. That's part 1. And part 2, if secured creditors holding pari passu security interest decide to stay out of liquidation, that is to stay under section 52, they need to all decide on a unanimous basis. That's what is proposed. Though the rules under SURFACE, etc., always talk about section 67% majority, two-thirds majority. So the majority rule should be brought here as well, that by majority, say 67% as in case of SURFACE, the creditors will decide to either join liquidation or have decided to stay out of liquidation. The decision of the majority should bind the minority. That's always been the way in case of joint mortgages as well. The majority drives the minority. That's always the principle. So I presume that while this is good, that the interest of other pari passu secured interest holders should be borne in mind, but the right should actually be given to majority rather than expecting unanimous decision. That was my submission. I'm not sure if anybody wants to add anything further.
Agree, sir.
Right, sir. And I must say to all of you that this was extremely enriching discussion with all of you. Some of you have mentioned on chat, will the presentation be shared? The presentation we will be very happy to share. We will be sending a copy of the presentation to ICICI IPA, and they in turn can forward the same to all registered participants. We will be also updating that based on the feedback that we received from all of you, and we'll be forwarding it to ICICI IPA for further action as they might want to take. Before parting, I must wish you all a very happy Republic Day, and I must wish you all a very happy Saraswati Puja as well. I know Mr. Devarajan sir is wanting to say something. So Devarajan sir, over to you. But from my side, unless there's something further for me to maybe add.
One small thing on the last slide. See, this unanimity which they have sought in terms of realizing the assets is because there are a lot of indivisible assets where one secured creditor has relinquished, one has not relinquished. And there are a lot of litigation because of that. So possibly to address that, this could have been done. But as you rightly say, there are issues in that. So need to think and deliberate better to understand how it will pan out. So the indivisible asset is a key issue here, where the rights of it has gone by majority. But there are issues. And the point is that how does the liquidator take care of the minority interest? Because he has in the liquidation estate, the minority portion. The majority portion is not in the liquidation estate. So now the question is that many of them are not willing to do a joint auction notice with the liquidator. So the liquidator says, if I am not involved, how will I take care of this interest? So these issues need to be addressed. That's the only small point I made. Thanks.
Surely, sir. Thank you very much. And thanks to all of you for extremely enriching discussions today. And from my side, that's all that I had to say. Over to Nitin Satija ji.
Sir, thank you very much.
Thank you, Vinod ji. Thank you.
Thank you, Vinod ji. Thank you. Thank you.
Great pleasure. Thanks.
Thank you very much.
Well done, sir. Well done.
Thank you very much. Thanks a ton. All
a good deliberation, sir. A good deliberation.
All
a
because
process,
of all
it's entirely good deliberation by everybody. Thank you. Thank you, one and all. Happy Republic Day. Thank you.
Happy Republic Day, sir. Thank you. To all the participants also. Thank you for taking out time for this session. We value whatever inputs that you have given, and we will pass it on to IBPN.
Thanks, and I think with this we come to the end of this meeting. Thank you very much.
Thank you, sir.